All right, Miss Orth,
Yes, Madam Chair.
we ready?
I am. How is my sound?
I can hear you fine.
Great, thank you. Good morning, everyone. My name is Felicia Orth. I'm a hearing officer appointed by the Oil Conservation Commission to conduct a hearing in this matter, which is an application by Wild Earth Guardians and the New Mexico Oil Conservation Division to consider proposed amendments to rules 19.15.29.6, 19.15.29.8, and 19.15.29.15 of the New Mexico Administrative Code. Concerns major and minor releases. The matter was docketed by the Commission Administrator as case number 21834. You can find all relevant documents, by the way, on the Oil Conservation Division imaging webpage using that case number 21834. We have all Oil Conservation Commissioners with us. Madam Chair, Adrienne Sandoval, Commissioner Warnell, and Commissioner Bloom. We also have a number of Oil Conservation Commission staff and Oil Conservation Division staff, including our technical host, Balin Lamkin. Let's see, our court reporter is Paul Baca, and a number of parties from whom I will ask for appearances in just a moment. We're conducting this hearing on a virtual platform, Cisco WebEx. There may or may not be a recording made of it or preserved of it. Having said that, the official record in this matter is the transcript. It is not any recording made of this session on a virtual platform. One of the features of a virtual platform, of course, is the chat function. Please be aware that the chat function is designed for this proceeding only to be used to communicate with the technical host, Mr. Lamkin. It should not be used for any other purpose. Please do not use it for any other purpose, and nothing in the chat will be preserved as part of the record. So,
Miss Orth,
yes.
I apologize. I was so excited to get the show on the road that I forgot to go over agenda items number 2 and number 3, which is approval of the agenda and approval of the minutes.
Oh, okay. I had thought this was the hearing, not the meeting, but I'm happy to mute myself for a moment and pick up in a few minutes.
Sorry, yeah, I think technically the hearing starts on agenda item number 4. So that was my bad here. So this is as Ms. Orth said, this is a meeting of the Oil Conservation Commission. I am Adrienne Sandoval. I'm the chair of the Oil Conservation Commission and head of the Oil Conservation Division. Also with us today, we have Commissioners Bloom and Commissioner Warnell, as well as Bill Brankard, who is filling in for the commission clerk today, and Chris Moander, who is commission counsel. Agenda item number 2 is approval of the agenda. Commissioners, have you read and reviewed the agenda? And is there a motion to approve it?
Madam Chair, I have read the agenda and I move to approve the agenda.
Is there a second?
I second that motion.
Mr. Brankard, would you do a roll call vote, please?
Certainly. Commissioner Bloom?
Approved.
Commissioner Warnell?
Here.
Chair Sandoval?
Approved.
Thank you. Motion approved.
Thank you. Second item on the agenda is approval of the May 13th and the June 4th, 2021 minutes. Why don't we take them individually? Is there, commissioners, have you reviewed the May 13 minutes? And is there a motion to approve those minutes?
Madam Chair, I have reviewed the May minutes and I move to approve them.
I second that motion.
Mr. Brankard, would you do a roll call vote for us again, please?
Thank you. Minutes of May 13th meeting. Commissioner Bloom,
Approve.
Commissioner Warnell,
Approved.
Chair Sandoval.
Approved. Passes unanimously. Now on the June 4th minutes, commissioners, have you reviewed those minutes? And is there a motion to approve them?
Yes, Madam Chair, I reviewed the June 4th minutes and I move to approve the minutes from June 4th.
Is there a second?
I second that motion.
Mr. Brankard, would you assist us again, please?
Thank you. Minutes of the June 4th meeting. Voting, Commissioner Bloom,
Approved.
Commissioner Warnell,
Approved.
Chair Sandoval.
Approved. Passes
you.
unanimously. All right, now on to agenda item number 4, case number 21834. And I will pass it over to our wonderful hearing examiner. My apologies, Ms. Orth. I just got too excited to get into it.
Thank you very much, Madam Chair. I won't repeat what I said earlier because I believe you were all present for it. So let me pick up with the identification of the Commission's rulemaking rules under which we will be conducting the hearing. Those rulemaking rules are in section 1915.3 of the New Mexico Administrative Code. The hearing will also be conducted pursuant to a procedural order entered by the chair on April 22nd of this year. The rules and the procedural order provide that technical testimony in particular will be taken under oath and subject to cross-examination. Public comment is not subject to cross-examination. The entities with party status in this matter include the Oil Conservation Division, which is one of the petitioners, Wild Earth Guardians, which is the other petitioner, the Independent Petroleum Association of New Mexico, which you'll hear acronymized as APANM, the New Mexico Oil and Gas Association, which you'll hear referred to by the acronym NEMOGA, and a number of environmental nonprofits, collectively known as interveners. These nonprofits include the Rio Grande chapter of the Sierra Club, the Pueblo Action Alliance, Citizens Caring for the Future, the Native American Voters Alliance Education Project, and Amigos Bravos. We will hear from several witnesses from those parties. We will also invite public comment. At the moment, I have just 3 or 4 folks who've indicated they wanted to offer public comment. And I will invite that comment between each of the technical presentations and again at the end. That is to say, we're going to hear first from the petitioners, then I'll invite public comment. Then we'll hear some more technical testimony and I'll invite public comment again. I'll keep inviting it until we have no one left to offer it. You can also submit public comment in writing until 5 o'clock today, pursuant to the chair's procedural order. And if you have something to communicate with us about, please again communicate with the technical host. You can use the chat function that way. By the way, if you have joined hoping to make mischief or disruption, please be aware the technical host has been asked to expel anyone doing that without discussion. if you still have something to say, please submit it in writing at that point. We'll take breaks every 90 minutes to 2 hours as needed. And the commission may deliberate following the close of the record, or may request post-hearing submittals from the parties and schedule the deliberations at a later meeting. They'll make that decision after the close of the record. So let me ask then at this point for appearances from the parties. Mr. Ames, will you begin, please?
Ms. Orth, Eric Ames, Office General Counsel, Energy, Minerals, and Natural Resources Department for the OCD.
Thank you. Mr. Timmons?
Thank you, Madam Hearings Officer. Daniel Timmons on behalf of Wild Earth Guardians.
Thank you. Mr. Cloutier?
Good morning, Madam Hearing Officer. Andrew Cloutier on behalf of the Independent Petroleum Association of New Mexico, or IPA&M.
Thank you. Mr. Feldemar?
Ms. Orth, Madam Chair, members of the Commission, Michael Felderwert and Adam Rankin with the Santa Fe Office of Holland and Hart, appearing on behalf of the New Mexico Oil and Gas Association.
Okay. And Mr. Meiklejohn?
Thank you, Madam Chair, Madam Hearing Officer and Commissioners. Douglas Meiklejohn with the New Mexico Environmental Law Center on behalf of the interveners.
Thank you very much. Let me ask if there are any preliminary matters. We did have a motion hearing on Friday, and there was an order issued in connection with that. So I don't believe there are any other preliminary matters, but I'll pause for a moment in the event a party would like to speak up in connection with a preliminary matter. No? All right. And then let me ask if the petitioners are going to make an opening statement, or if we will leap right into a witness presentation.
Ms. Orth, I seem to be having a little problem now with my my audio. Did you just ask whether the petitioners had opening statements?
Yes, I did.
I apologize. I may need to move at some point to get better reception. For some reason, it just began to break up. Yes, Madam Hearing Officer, OCD would like to make a brief presentation. We've discussed this with Mr. Timmons from Wild Earth Guardians, and we've agreed that OCD will go first, followed by Mr. Timmons.
Thank you very much. Please go ahead.
Thank you. Good morning, Madam Hearing Officer, Madam Chair, Commissioners Warnell and Bloom. My name is Eric Ames. I'm an attorney with the Office of General Counsel, Energy and Minerals and Natural Resources Department here on behalf of the Oil Conservation Division. Today, the Oil Conservation Division and Wild Earth Guardians present a joint petition to amend Part 29, commonly known as the spill rule. We propose 3 changes to Part 29. First, we propose to revise Section 6, the objective section, to change the objective to reflect new subsection 8A. Second, we propose to add new subsection 8A to prohibit major and minor releases. And finally, we propose to revise Section 15, the enforcement section of Part 29, to conform with the Commission's enforcement rule in 1915-510 NMAC. The petitioners also, OCD proposes us one modification to the petition on its own, and that is to add the phrase except as provided in parts 27 or 28 into the new subsection 8A. Parts 27 and 28 are rules recently adopted by the Commission to regulate venting and flaring of natural gas from upstream and midstream facilities. And the exception is required to accommodate certain releases that are allowed by those rules. This hearing is noteworthy for a couple reasons. First, this is, to my understanding, the first petition to the commission filed jointly by the agency and an environmental group. And also, this petition is supported by the two major trade associations for the oil and gas industry in New Mexico. No person has entered an appearance in opposition to the petition. It's also noteworthy because the division, Wild Earth Guardians, and the trade associations have agreed to streamline this proceeding by presenting a single witness to present direct testimony in support of the petition. The division will present Mr. Jim Griswold, who is currently Special Projects Manager and formerly OCD's Environmental Bureau Chief, who was responsible for or rephrase that, he was the agency lead for the adoption of the current version of Part 29 in 2018. Mr. Griswold will provide an historical background on the development of Part 29. He'll explain that the prohibition on major and minor releases is appropriate and necessary because of the number and volume of releases and the actual or potential threat to public health and the environment. He'll describe the proposed modification and why it is necessary to accommodate parts 27 and 28. And then finally, I'd like to, before proceeding with direct, like to address a concern raised regarding how OCD intends to use its enforcement authority if the commission adopts the proposed changes prohibiting major and minor releases. These concerns, we understand, are prompted by the OCD's or the commission's recent grant of authority to the division to assess civil penalties for rule violations. The division recognizes that releases occur for a wide range of reasons. Some releases may be unavoidable. They may be beyond the control of a prudent operator employing best practices, but other releases may be preventable by the exercise of due diligence. Whether a release is preventable or not requires an evaluation of the facts of the circumstance. Like any enforcement action, the division intends to consider the facts in making a decision whether to assess a civil penalty and how much to assess. Relevant considerations include the volume and location of the release, the effect of the release on public health and the environment, the operator's effort to prevent or mitigate the release, the operator's response to the release, and the operator's cooperation with the division in identifying and remediating the release. With respect to the civil penalty, the division relies on a civil penalty calculation method to determine the amount of the civil penalty. OCD intends to revise that method to include this new prohibition on releases if adopted by the commission. And when it does, the division will consult with the stakeholders, including the oil and gas industry and the environmental community, as it has done in the past. And the division would like to reiterate that it remains open to considering other potential changes to Part 29 and invites the parties to work with the division to improve its regulatory structure for the benefit of the people of the state of New Mexico. And with that, I'd like to call Mr. Jim Griswold as the division's witness.
All right, I'm going to ask Mr. Ames if there are others with opening statements. Mr. Timmons?
Of course.
That's all right.
Thank you.
Mr. Timmons, did you have something to add by way of an opening statement?
Yes, very briefly. Thank you, Madam Hearings Officer. Madam Hearings Officer, Chair Sandoval, members of the Commission. Again, my name is Daniel Timmons, and I'm appearing here on behalf of Wild Earth Guardians. I want to start by just thanking the many folks who have gotten us here today, starting with the Commission, particularly Chair Sandoval, and supporting scheduling this rulemaking proposal for this public hearing here today. Commission staff, including Ms. Davidson and Mr. Moander, have been working hard behind the scenes to make sure that all the procedural hurdles and hoops have been properly jumped through. Finally, Oil Conservation Division, its leadership and its staff in supporting this proposal and joining together with Guardians to present this here today. And in a unique thank you out to the industry participants here, NMOGA and IPA&M. We're grateful for your participation here. And finally, the other interveners, Sierra Club, Pueblo Action Alliance, Citizens Caring for the Future, Native American Voter Alliance Education Project, and Amigos Bravos. We thank you for your support for this proposal. And finally, any concerned citizens here today, we're grateful for the support of the public in participating in this important issue. So today is the culmination of many months of collaborative work to get this proposed rule before the Commission. There have been certainly some procedural challenges and delays along the way, including additional delays this morning, but we're finally here, and we're ready for the Commission to consider a straightforward proposal to prohibit major and minor releases of oil, gas, and related waste products during oil and gas development and production. Guardians and the Oil Conservation Division proposed this rule because, quite simply, there are too many spills and releases from New Mexico's oil and gas industry. 3 reported spills a day in 2020, with more than 12,000 reported from 2010 through 2020. It's just too much. As OCD's witness, Mr. Jim Griswold's written testimony indicated, some, if not many of these spills are preventable, and after the fact reporting and cleanup, as currently required, is not always enough to fully protect public health and the environment. As a general principle, spills and releases of toxic substances should be prevented from happening in the first place. And that's what this rule is all about. Quote, major and minor releases are prohibited. That's the crux of this proposal. So this proposal is intended to provide the division with essentially an additional enforcement tool to address the serious and ongoing problem of releases, a problem which threatens public health and the environment. So finally, I want to again thank the Commission and everyone involved for getting us to this point here today. And I urge the Commission to adopt the rule proposed by Guardians and the division, subject to those minor modifications proposed by OCD in its notice of intent. Thank you.
Thank you, Mr. Timmons. Let me ask Mr. Cloutier, are you interested in making any kind of opening statement?
Yes, Madam Hearing Officer, and there will be closing statements too, I believe. Is that correct? At the conclusion?
So if the Commission decides to deliberate without post-hearing submittals, I will invite closing statements. If the Commission decides to deliberate at a subsequent meeting, I may invite opening statements in writing.
Okay. Thank you, Madam Hearing Officer. First of all, appreciate the Commission and the participants participating in this rulemaking. Our relationship with Mr. Ames and Mr. Timmons and Mr. Felderwert have been amiable and professional, and we appreciate all of the efforts to move this to hearing. IPA&M supports in general the clarifications to the rulemaking that are occurring here. IPA&M remains concerned about the use of civil penalties to discourage reasonable and prudent operators from investing in New Mexico. IPA&M's members are generally small players in the oil and gas business. They're proud contributors to New Mexico's public fisc through royalties, taxes, and jobs. Many of our members have significant and exclusive presence in New Mexico, so they create both good-paying blue-collar jobs and provide opportunities for educated New Mexicans to stay at home and work as accountants, engineers, geologists, and the other white-collar jobs that sometimes in our industry are in remote areas far from New Mexico. In short, IPA&M is invested in New Mexico's future. It wants to make New Mexico a better place. Our members live in New Mexico, raise their families in New Mexico, and enjoy New Mexico for all its beauty. The rule change proposed by the division and Wild Earth Guardians is not opposed by IPA&M or, as the parties have noted, any party to this proceedings. The parties who entered into their appearances early in this proceeding have also agreed on an amendment that makes clear that the changes to Part 29 to the commission's rule would not apply to the types of releases that are governed by parts 27 and 28 of the commission rules, and IPA&M supports that change to the proposed rulemaking. Two of IPA&M's purposes to participate in these proceedings are to seek an understanding about how the division would use its enforcement powers under the rules and to comment on the limited utility of civil penalties in many instances where releases occur in the oil field. IPA&M appreciates Mr. Ames's comments and is looking forward to working with the division on its implementation of the proposed enforcement protocols. When the commission adopted the penalty rule, the division referred to it as adding a tool to its toolbox of options available to ensure compliance with its rules. IPA&M believes this is an apt metaphor. Some jobs require a certain tool, and for other jobs, that tool is never needed. Like a toolbox, the division has many tools in its disposal to seek regulatory compliance, and civil penalties is just one. On the division's current C-141 form used for reporting certain releases, there are 11 specific categories for causes of releases and a 12th or catch-all cause of other. As Mr. Ames notes, it may not be possible to speak in absolutes, but some of the categories of releases are usually, if ever, are preventable. For example, lightning strikes are a common natural phenomenon in New Mexico. Vandalism is a cause of release that requires the intentional conduct or misconduct of a third party. Operators can't prevent either. More importantly, oil and gas wells and other facilities used in oil and gas operations are large engineered systems with many manufactured parts. This is true in any sort of system like that, whether our own automobiles or anything else. Parts wear out and fail. In well facilities, some such failures can result in the release of oil, gas, or produced water. Penalizing operators for ordinary equipment failure is not going to improve the public health and safety of New Mexico. Additionally, New Mexico legislature recently adopted the Produced Water Act, which encourages oil and gas producers to recycle and utilize produced water in their oil and gas operations. This statute advances the laudable public policy of reducing the use of fresh water in oil and gas operations. In order to accomplish that, again, large engineered systems are needed to move produced water to recycling facilities where they are stored, and those pits are governed by these commission's rules. And then the water is again moved to new oil and gas wells where drilling or completion operations are occurring. Again, IPA&M believes that penalties on reasonable and prudent operators for releases that are properly addressed could discourage the recycling and use of produced waters in contravention of legislative policy. Additionally, while the amendments make all releases illegal, or major and minor releases illegal, operators already have systems in place to protect the public health and welfare, and some of those systems are governed by the commission's rules. For instance, in Part 17 of the rules, it is required for construction of below grade tanks that liners be used, and above ground tanks must be constructed with berms. These measures acknowledge the risk of releases, even unintended releases, and put in place measures to contain those releases and protect the public health and welfare. Even when they are preventable releases, for instance, one category is human error, which almost definitionally is preventable, since if there's no error, there's no release. Responsive operator will be spending money on vacuum trucks, roustabout crews, disposal fees for contaminated surface materials, resurfacing, and other costs to respond to the release. Where the operator is responding, we urge that the commission and the division consider those responses and that penalties are inappropriate. IPA&M hopes that the penalties are used appropriately and judiciously, and when applied to releases, if all major and minor releases are to be made illegal. And again, we appreciate the opportunity to participate. Thank you, Madam Hearing Officer.
Thank you, Mr. Cloutier. Mr. Felderwerk, do you have anything by way of opening?
Just real brief, Madam Hearing Officer, Madam Chair, members of the commission. I would say NMOGA, I believe, disagrees with the opinions and the characterizations when it comes that we've heard with respect to the number of releases or the impact of these releases, or when they're not preventable. But those types of technical issues are really not before the division here today, because as everyone has observed, these changes are really straightforward, without objection by the division, the environmental groups, or the regulated industry. And based on our review of the testimony that's been filed by Mr. Griswold, his expertise, and I will say many years of public service that he has put in, support these changes. So this should not be a very long hearing. We hope it's not a long hearing, and we appreciate the opportunity to be part of this.
Thank you very much. Mr. Meiklejohn.
Thank you, Madam Hearing Officer, members of the commission. I won't repeat what Mr. Timmons said about the number of spills and the impact on New Mexico's public health and environment, but the groups that I represent, the Rio Grande chapter of the Sierra Club, the Pueblo Action Alliance, Citizens Caring for the Future, NAVA, EP, and Amigos Bravos, agree that there are too many releases, and that they have the impact, they have the potential at least to have very adverse effects on public health and the environment. The particular groups that I represent and that will participate in the hearing represent a cross-section of environmental groups and nonprofits, as you characterized them, Madam Hearing Officer, but they also represent frontline communities. And we think, and my clients think, that it is important for the members of the commission to hear from frontline communities that are actually impacted by releases and other effects of the activities of the oil and gas industry. As you know, we proposed amendments to the changes that have been advocated by the division and Wild Earth Guardians. Those changes were ruled to be outside the scope of this hearing. However, our clients do still support the amendments that have been proposed by the division and Wild Earth Guardians. And we welcome the opportunity to explain why we support those changes to the commission. Thank you very much.
Thank you, Mr. Meiklejohn. Mr. Cloutier, I believe you're not muted. And I know several of us are going to need reminders through the day. As panelists, if you're not speaking, please mute yourself. And if you're not speaking and you're not a commissioner or me, you are also welcome to turn off your video. It's up to you, really. All right. Let's see. Let's get to Mr. Griswold. Mr. Griswold, can you turn on your camera, please? Wait.
Good morning.
Griswold? Oh, good morning. If you would, please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. Mr. Ames, whenever you're ready.
Thank you, Ms.
Would
Orr.
you please spell your name for the record? This is the court reporter. Your full name for the record. Thank you.
My first name is Jim, J-I-M. Last name Griswold, G-R-I-S-W-O-L-D.
Great. All set, Mr. Baca? Well, hearing nothing, I'll continue. Jim, good morning.
Good morning, Eric.
Pleasure to be here today with you. Could you please state your full name for the record?
My name is Jim Griswold.
And what do you do for the Oil Conservation Division, Mr. Griswold?
Currently, I am the Special Projects Manager for the OCD.
What's that involve?
Oh, any myriad of topics that come up in the course of operations overseeing the oil and gas industry. Probably the most prominent current issue that I've been dealing with is an unstable brine cavern in underneath a developed portion of Carlsbad. But it's any other plethora of projects that may come up.
Before you became Special Projects Manager, what did you do for the division?
I was its bureau chief for the Environmental Bureau for approximately 6 years. Prior to that, starting in 2008, when I was initially hired by the OCD, I functioned as a senior hydrologist. So throughout my tenure with the division, that's pretty much what I deal with. Almost any aspect regarding releases from oil and gas activities, from the reporting to the characterization of the release to cleaning things up, and then also the development of any rules and guidance through the years in that regard.
So would it be fair to say that you're familiar with Part 29?
Yes, sir, very much so.
Were you involved in the adoption of Part 29 in 2018?
Yes, I was. I was the division's lead in that effort.
Is your resume reproduced as Exhibit 1 to OCD's pre-hearing statement?
Yes, it is.
Okay. So let's turn to the petition now. What is the purpose of the joint petition filed by Oil Conservation Division and Wild Earth Guardians?
Well, it's to make it clear in the rules that a release in and of itself is against the regulations. Currently, that's not the case.
And what are the, in general, what are the three parts, the three sections of Part 29 that we propose to amend?
Let me grab it here real quick. Sorry, Mr. Ames. So I'm looking at OCD Exhibit 6, the proposed rule changes. And well, generally we refer to the spill rule as Part 29 regarding releases. And so at the near the beginning of that group of regulations and the objectives, we've now just added a simple phrase to prohibit releases. And then therefore the language thereafter remains the same. Then in subsection, or I guess it would be section, 8 of Part 29, to add a new subsection in there, displacing current subsection A with a new one that, again, explicitly prohibits major and minor releases, except as otherwise provided in Parts 27 and 28, which are the recently adopted venting and flaring rules that the Commission adopted just earlier this year. Then the third portion of the regulation that we're proposing to change, excuse me, is in section 15, the enforcement section. And that language changes there are to bring the spill rule, Part 29, pretty much into concurrence with the enforcement provisions in Part 5 of the OCD's rules, which were modified in February of last year.
Great, thank you. Before we move on, I'd like to just touch briefly on the history behind Part 29. Can you give us a thumbnail sketch following your testimony, your direct testimony in the case, of how we got to where we are today with respect to Part 29?
Well, I started with the division in 2008, but speaking to my knowledge, at least, of the division rules prior to that time, in OCD Exhibit 2, we filed what was formerly known as Rule 116, and that dates back to 1991. And if you review the rules at that time, they primarily focused just on the notification to the division that a release has occurred. Not much, if any, discussion as to what is done to characterize and address that release thereafter. So that was the rule adopted in 1991. In 1993, the division came out with a guidance document dealing with remediation of spills. And it advanced the ball down the field, so to speak, fairly well. However, there were some problems with it. One, that it was guidance. It didn't have the full weight of rulemaking on it. And the other significant problem that I observed with that guidance document was it did not address impacts from produced water, at least to the extent of chloride. There's a whole lot of salt in produced water, and that chloride, which is a constituent of salt, is probably one of our prime contaminants of concern in that regard. In 1997, the rules were modestly, Part 116 or Rule 116 was partially modified, really just kind of tightening up the language. But again, there wasn't a whole lot of direction either to the division or to industry as to what the response to a spill should be, other than to notify the division. In 2008, about the time that I came on with the division, we renumbered our rules. It was part of a larger effort within the OCD. And that's when it went from Rule 116 to Part 29. But again, Part 29 in 2008 just primarily dealt with the definition of a release, major or minor, and then what the notifications procedures were of a responsible party when a release was discovered. With respect to corrective actions thereafter, it simply said that they must proceed per a division approved plan. That did not provide direction to, like I said, either to the responsible parties or to the OCD in terms of what forms that should take. As a result of that, we went through the effort starting back in 2007 to expand Part 29 to lay out a real process, not just for notification of a release, but also those responses that a responsible party must take thereafter, such that the release is properly characterized and then properly cleaned up. And so it lays those procedures out for the division and for responsible parties. It also makes it clear that even though a release may occur of a volume that is what I refer to as a less than a de minimis volume, meaning it's not reportable, 5 barrels of liquids, for instance, that those releases still must be addressed by the operator and must be cleaned up.
Great, thank you. I see that you have 4 exhibits that reflect the changes over time to Part 29. Exhibit 2, 3, 4, or exhibits 2, 3, 4, and 5. Is that correct?
Yes, sir.
Okay, thank you. I'll move admission of exhibits at the conclusion, Madam Hearing Officer. So Jim, can you tell the commission why the division believes that the proposed changes to Part 29 proposed today are needed?
Well, it's part of an effort to reduce, hopefully, the frequency and severity of spills because they are adversely affecting public health and the environment.
In terms of, I apologize. The camera is. Did you complete your statement there?
Yes, Eric, I did.
Mr. Ames, if you need to turn off your video, I would.
Jim, can you hear me?
But it might help.
Okay.
Yes, Mr. Ames, I can hear you. I'm not sure if you can hear
I
me,
will
though.
turn off my video with your.
Thank you. Thank you.
Okay. Jim, did you do an analysis of OCD's database regarding leases reported between 2010 and 2020?
Yes, sir, I did.
Mr. Ames, are you still with us?
I can hear you now, Miss Orth. My audio is cutting in and out. Did you hear my question, Jim, regarding your analysis of releases between 2010 and 2020?
Yes, I heard your question, Mr. Ames, and I responded in the affirmative. Yes, I have.
Okay, I missed that. Could you tell us what you found?
Well, basically, releases occur at a rate of between 3 and 4 releases per day. I think the actual number is about 3.4. So during that 10-year period, we looked at, well, there were approximately 12,000 releases occurred. About 7,000 of those releases involved produced water, which is a waste product that comes up when you produce oil and gas. 4,000 of them involved releases of crude oil. As an example, during just the prior year, 2020 alone, we had more than 700 releases involving produced water. 330 of those were considered major. Now, we define major, or one of the criteria for defining a major release is volume. And so that's a release of greater than 25 barrels of liquid. And a barrel is 42 gallons, if you're not aware of that. Of crude oil releases, nearly 400 releases involve crude oil, of which 90 were considered major, i.e. that released volume is greater than 25 barrels.
Jim, what is your view on the preventability of these releases in a general sense?
That's a difficult question, Eric, Mr. Ames. Accidents do happen, but they happen for various reasons, some of which are preventable, some of which are not. I guess I suppose you can make the argument that all releases are preventable, but I don't think that's really the case. Perhaps a significant fraction of releases are preventable by the adoption of best management practices by operators.
Thank you. So that said, I'd like to review the changes that are being proposed. First, with respect to Section 6, what change does the division and Wild Earth Guardians propose?
In Section 6, the objective portion, we're adding the phrase prohibit releases. Currently, the language says to require persons who operate or control the release, basically to, I'm going to kind of jump ahead and paraphrase it a bit, that they actually deal with that release. But like I say, we're adding this section now that says, well, would explicitly say that releases are prohibited. And then I guess there's another minor change in the wording, use of the word procedures for rather than procedures thereafter, just to clean up the English on it a little bit. And so that's subsection 6 or section 6.
How about Section 8?
As I had mentioned earlier, currently provision A in section 8 establishes requirements. We were going to actually push that down now to section B, and then everything thereafter gets, C, D, E, and F to insert new language, subsection A, prohibition, which states, except as provided in parts 27 or 28, major releases and minor releases are prohibited. It's pretty direct language.
And how about the proposed modification with respect to parts 27 and 28?
Well, I'm not sure if you maybe didn't hear all my answer in there, Eric. Parts 27 and 28 deal with venting and flaring of natural gas. And they were just recently adopted by the commission this year. And so the reason they're included in the language now is that certain venting and flaring actions are actually allowable. Otherwise, I guess you could refer to as authorized. Whereas Part 29 really deals with unauthorized releases, and it's just to make sure that we're clear or in agreement with Parts 27 and 28.
Excellent, thank you. And I apologize, my audio is unexpectedly creating problems here. So let's turn to section 15. What is the change? What changes are being proposed for section 15? If you could just review those quickly.
Okay, section 15 is the enforcement provisions in Part 29, i.e. what can the division do to a responsible party if they do not adhere to the regulations. Similarly to parts 27 and 28, excuse me, part 10 of our regulations, or excuse me, part 5 of our regulations, which deals with the enforcement and compliance, was modified in February of last year, 2020. And so that post dates the current spill rule, which was adopted in August of 2008. And so it's catching up with that language in regards to enforcement provisions.
Thank you. Earlier you said that you believe these changes to Part 29 were necessary and appropriate. Can you explain why providing the additional tool of prohibiting major and minor releases and subjecting them to enforcement authority would be beneficial for the public health and environment?
Well, if it results in less releases occurring, then indeed it would be beneficial.
Thank you. Nothing further. I would move the admission. One more thing before I do that. Jim, is the division's proposed modification to section 8A that you referenced earlier regarding parts 27 and 28 reflected in Exhibit 6?
Yes, it is.
Thank you. Move admission of OCD Exhibits 1 through 6.
Thank you, Mr. Ames. Let me pause a moment in the event a party has an objection. Exhibits 1 through 6.
No objection, Madam Hearing Officer.
All right, thank you, Mr. Micklejohn.
No objection.
Was that you, Mr. Timmons?
Mr. Cloutier.
Oh, Mr. Cloutier. Thank you very much. All right. So hearing no objection, OCD Exhibits 1 through 6 are admitted. Let me ask for questions at this point. Because we're on a virtual platform, I will do this essentially as a roll call. Mr. Timmons, do you have questions of Mr. Griswold?
No, Madam Hearings Officer, no questions for Mr. Griswold.
Thank you. Mr. Cloutier?
No questions. Thank you, Madam Hearing Officer.
Thank you. Mr. Felderwart?
Yes, Madam Hearing Officer, just a couple. Mr. Griswold, first off, I want to thank you for your 16 years and counting of your expertise in public service to the division. And secondly, you mentioned the existing rule, Part 29. And I just want to make it clear for the record, Mr. Griswold, that existing rule, Part 29, currently is comprised of 8 pages of small, single-typed regulations that look something like that. Is that right?
Yes, sir.
Yeah. Okay. And you mentioned you were around or a big part of, and I know you were a big part of in 2018 of the changes that were proffered. Is it fair to say that what occurred in 2018 was pretty substantial overhaul of the Part 29 that governs releases?
It was very significant, Mr. Felderwart.
And would you agree with me that what occurred in 2018 and the changes that were made was the product of testimony from numerous technical experts, I believe, including yourself, correct?
Yes, sir.
Okay. And when you look at that rule as it currently stands, it addresses many topics, Mr. Griswold, first starting with definitions, which you referenced. Is that right?
Yes, actually, the current rule is not one of the exhibits, but is it okay then if I refer directly to that anyway, nonetheless?
Yes. And you may not need to, because I know you know this rule very well.
Well, I'm getting older too, Michael.
Okay. You're aware in that within this 8 pages that I'm looking at, we have a section dealing with definitions that you referenced, right?
Correct.
Okay. There's a section dealing with releases and including the notification requirements.
Yes, in addition to what initial response a responsible party should take even prior to notification. Once they come across, they discover a release, the things they should do.
And one of the things that was required in 2018, you'll recall, Mr. Griswold, is that they have to clean it up no matter what the volume, right? They have to remediate it. Okay.
Yes, sir.
And within this 8 pages of rules, there was discussion, testimony that supported site assessment at the spill site, correct?
Yes, and also the contents therein. What are the minimum pieces of information that the division needs to know?
And I think some people, and at the title of it, and basically the characterization of those releases, right, Mr. Griswold?
Yes, sir.
Okay. And then there's a whole section on the remediation required and the closure that's required, depending upon the site assessment and characterization. Is that right?
Correct.
And then a whole section on what they call restoration, reclamation, and revegetation.
Yes, sir.
Okay. And that's all comprised within these 8 pages and codified under 19.15.29.1.
19.15.29 NMAC. Yes, sir.
Okay. All right. Thank you. That's all the questions I had.
Thank you, Mr. Felderwart. Let's see, Mr. Micklejohn.
Thank you, Madam Hearing Officer. I do have some questions. Mr. Griswold, you, in your direct testimony, you gave a couple of numbers of types of material that were involved in spills or releases. One of them, I believe, was 400 releases, consisted of crude oil. And you also gave a number for releases of produced water, and I missed that. What was that number?
During 2020, the last calendar year, operators reported to the division 700 releases involving produced water.
Thank you.
They also reported 398 releases involving crude oil. Now, some of those releases will be the same release because you could release both produced water and crude oil in a single event.
Do you have any estimate of how many of those releases involved both fluids or both types of fluids?
Not off the top of my head, Mr. Micklejohn, but needless to say, typically when you release crude oil, there'll be a little bit of produced water in it. And conversely, when you release produced water, or if a produced water release occurs, there will be crude oil in that produced water as well.
All right, thank you. In your direct testimony and in your written testimony, you referred to releases endangering public health or the environment. Could you explain what you mean by that, please?
Well, there are chemicals in produced water and in crude oil which are toxic, both to humans and to plants, natural wildlife. They could potentially, if the release is large enough where it's not addressed in an appropriate period of time, could actually migrate their way into groundwater sources as well.
And would there be an additional or different issue if those fluids or materials came in direct contact with people or domestic animals or wildlife before those materials got to groundwater?
They could pose a problem, yes, sir.
Do you have a sense of what kind of a problem they could pose?
Well, I'm not a health physicist or an epidemiologist or anything, Mr. Micklejohn, so I'd probably be hesitant to offer testimony in that regard.
All right. You also mentioned site assessments in your written testimony. Could you explain what you mean by site assessments? I assume it's a site assessment at the site at which a release occurred. Is that right?
Yes, the purpose of a site assessment is to, if I would make I guess maybe a medical analogy to it, is to diagnose the patient before you provide a cure for their ills, perhaps. And so that's what that assessment is to define the vertical and lateral extents of contaminated soil and groundwater. So you know what it is you're trying to deal with and to what extent, where it's at, so that you adequately address it all.
Would a site assessment also include an analysis of the material that was spilled?
Well, there is testing that is undertaken as part of that assessment. And to try to, in essence, kind of simplify that process, the major contaminant of concern in crude oil are hydrocarbons. And so as part of that characterization effort, and then again, at the end of a remediation effort, when you prove that you or show to the division that you cleaned it up, we have you assess the levels of hydrocarbons. In produced water, the primary contaminant of concern is chloride. It's listed as a groundwater contaminant in New Mexico regulations. And so if you were to clean up the hydrocarbon, clean up the chloride, then we're fairly certain that any other constituents that may be in the crude oil or produced water were cleaned up as well.
Thank you. When you're talking about a site assessment, would a site assessment include assessing what's going on only at the point at which the release occurred, or if the release, for example, spread material in an area of several hundred yards around the actual release site? Would a site assessment address what's going on within that radius?
Yes, sir, it would.
Objection, scope. Mr. Griswold testified regarding site characterization only to the extent that he was explaining the history of Part 29. At this point, Mr. Micklejohn has asked several questions about characterization, and now they they appear to be in support of the proposed modifications that the commission declined to hear today. Mr. Micklejohn is entitled to ask these questions in a hearing on his own proposed modifications, but not about OCD and Wild Earth Guardians, which is limited to 3 very specific changes to the rule.
Yeah.
May I respond?
Go ahead, please respond,
Officer.
Mr. Micklejohn.
Thank you. Mr. Griswold testified that site assessments are done. I'm trying to find out what those site assessments consist of.
And Mr. Micklejohn, my memory is that site assessments and the rule are covered in 1 or 2 other sections of this rule entirely. Mr. Griswold, would you either confirm that for me or state otherwise?
Yes, Madam Hearing Officer, in section 19.15.2911, it's entitled Site Assessment and Characterization. And indeed there it puts the parameters around what a site characterization is.
All right, so Mr. Meiklejohn, I'm going to uphold the objection and ask you to move on because section 11 is not under consideration in this rulemaking proceeding.
Thank you, Madam Hearing Officer. Mr. Griswold, you also referred in your written testimony to notification of a release. Who receives that notification?
Presently under 19.15.29.9, so i.e. section 9 of part 29, well, actually 9 and 10 are the release notification requirements. So not only is the division notified of a release within a specified period of time, but if that release were to occur either on state, federal, or tribal lands, or at least there was impact, those lands were impacted by a release, either the state land office, the BLM, or the tribal authority would be notified as well by the operator.
Thank you. I don't have any other questions.
Thank you, Mr. Meiklejohn. Commissioner Bloom, do you have questions of Mr. Griswold?
Yes, thank you very much, Hearing Officer Worth and Madam Chair. Yes, good morning, everyone. I'm Greg Bloom. I'm the designee of the Commissioner of Public Lands, Stephanie Garcia Richard. Mr. Griswold, thank you so much for your testimony today. Just a couple questions. IPA&M, Mr. Cloutier, and also a letter that we received from Intrepid, a potash company working in southeastern New Mexico, both expressed concerns about penalties that could impact oil and gas operators and potentially this potash company. I want to be very clear when I vote on this, as we work on this rule and vote on it about penalties. There's currently in Part 29 an enforcement section. At this point in time, is OCD able to level fines on someone that has a spill under the current rule as it stands today?
Commissioner Bloom, actually, under the current rules, the OCD would be allowed to pursue a fine against an entity that did not follow the rules, meaning they didn't properly address the spill, didn't properly characterize it, didn't clean things up. There is not a provision in the regulations currently that would allow the division to assess a penalty or a fine, however you want to phrase it, simply for having a release.
And so it's, I think this is a question. And is it the changes to section 6, I don't know, pull that up here as we're speaking, of part 29 that would now allow for penalties to be assessed, essentially prohibiting the release, and I guess under section 8 as well, creating a prohibition? Is that your understanding of where this increased ability to levy a financial penalty comes in?
Correct.
And just to be clear, we're changing in section 15, the language is going from an agreed compliance order to a stipulated final order. That's to update part 29 in relation to other rule changes that were conducted in 2020. Is that what you said, sir?
Correct. To make it, I don't know if the right legal word because I'm not an attorney, but to make it jive, if I can use that phrase, with Part 5, which deals with enforcement and compliance in our regulations.
And then, just to be explicit here as well, is it your belief that we will see less spills in the future if these rule changes are made? Because companies, operators would fear a financial penalty.
That would be a hope. I don't know if that's well, I know it's not a technical term, but
I got it. So that's the mechanism, though, is that we would prohibit spills, increase the ability of OCD to level a penalty, and then we hope that we see improvements to public health and the environment and less waste because of the adoption of these rules. Correct?
correct.
Okay. I have no further questions at this time. Thank you. Thank you, Mr. Griswold.
Thank you, Commissioner Bloom. Commissioner Warnell, do you have questions of Mr. Griswold?
Thank you, Madam Hearing Officer. I have no questions at this time with Mr. Griswold. None whatsoever.
Okay. Thank you. Madam Chair, do you have questions of Mr. Griswold?
I have a couple questions. Mr. Griswold, and if you guys were at our last hearing, these will sound very familiar to you. Do you believe that this rulemaking came out of a collaborative process?
Yes, ma'am, it did.
Are you supportive of this rule change?
Yes, I am.
Okay. Just to sort of make sure I understand. So is there, does OCD have a breakdown of sort of the spills that you classified as maybe could not have been prevented versus ones that could have been prevented? Is there a breakdown on like percentage wise what that looks like?
Madam Director, Madam Chair, I currently don't have the statistics for it, but when a release, when we're provided notification of a release, the cause of the release is part of that notification. And there are, under the digital system wherein these things are currently submitted, a selection of causes for the release, including other, if it's not otherwise listed in there. And so any statistical analysis would incorporate that stated cause by the operators to why the release occurred.
But do you know of like the breakdown at all, or has OCD done an analysis of what the breakdown looks like for releases that were potentially preventable versus not?
No, ma'am, we have not at this point.
But the intent with this change is that it's believed that operators will take or maybe do more due diligence up front to prevent releases if there is more potential for a monetary penalty on the back end if they don't.
Correct.
Okay. That's all for now. Thank you.
Thank you, Madam Chair. Mr. Ames, was there any questioning you felt you needed to follow up on with Mr. Griswold?
No, Ms. Orth.
All right, thank you very much. If there's no reason not to excuse Mr. Griswold, we will thank him for his testimony. And thank you very much, Mr. Griswold.
Be well.
Let's see. Mr. Ames, do I understand now we're going to turn to Mr. Timmons?
Yes, so perhaps I should formally say the state rests.
All right, thank you. Mr. Timmons, what would you like to say? Anything further at this point in support of the petition?
No, Madam Hearings Officer. Wild Earth Guardians has no additional witnesses.
All right, thank you very much. Do I understand, perhaps from the order in which we took folks on Friday during the motion hearing, that I should go to Mr. Cloutier next?
Thank you, Madam Hearing Officer. IPA&M is not presenting any witnesses or exhibits.
All right, thank you. Mr. Felderwart?
Thank you, Madam Hearing Officer. New Mexico Oil and Gas Association likewise is not presenting any witnesses.
Thank you. We would turn now to Mr. Micklejohn. It occurs to me, though, we've been going an hour and 15 minutes. Would this be a good time for a short break, Mr. Micklejohn?
Madam Hearing Officer, it would, but we have one witness who needs to leave at noon. So I'm wondering if she could make her presentation before we take that break.
Oh, certainly, certainly. Tell me the name of your witness.
Her name is Kaylee Shoup.
Kaylee Shoup. And would you spell first and last name there, please?
Yes, Kaylee is Kayley, and Shoup is Shoup.
All right. So I had just snapped that I had said I would invite public comment in between the presentations, but because we need to get Ms. Shoup on and off, I will take public comment after Ms. Shoup and after a short break. So please hang in there with us. Ms. Shoup, would you raise your right hand, please? Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. Mr. Micklejohn?
Ms. Shoup, have you prepared a statement to read to the commission this morning?
Yes, I have. And thank you for letting me go out of order, everyone. I appreciate it.
Would you please proceed with your statement?
Yes. So my name is Kaylee Shoup. I am a community organizer with Citizens Caring for the Future in Southeast New Mexico. Citizens Caring for the Future is a group of engaged citizens in the Permian, and we seek to find an informed and safe path to ensure protections for our community in the face of the rapid oil and gas development that is happening in southeastern New Mexico. I was born and raised in Carlsbad, and I am now serving as an organizer solely because of the extensive impacts from oil and gas development in my community that I have borne witness to for the past 3 years. The issue of produced water and oil field waste is one that is very near and dear to my heart because it has been my entry point to my current work. In late 2019, I began to learn about the industry that was surrounding my home. At that time, the Produced Water Act, HB 546, had just passed, and the New Mexico Environment Department and the Oil Conservation Division were holding meetings to provide stakeholders with information on produced water and the upcoming rulemaking process. I attended that public meeting, and to say the experience was eye-opening would be an understatement. What stuck with me, though, was a family that was there that evening. It was a school night. They had hauled their school-aged child to this meeting to voice their concerns. Both parents bravely stood up and stated that they had produced water dumped on their land. They had contacted NMED, who had limited authority to act. That evening, I watched as they were again told about the agency's limited authority to act. They were told by NMED that there was no form of recourse to be taken other than what OCD requires to report the spill. That meeting was a very eye-opening and life-changing moment for me. I didn't know how I would be able to help, but I knew that this family in my community had been harmed and that they had very few places to turn for assistance. A year after that meeting, I was introduced to Penny and Dia Coyne. They are two of the most amazing advocates I've ever met. Days before meeting them, I had actually read their story of having a produced water spill on their land in early 2020. I learned of the problems after meeting them that their family faced because of the spill, problems that included health issues, having to euthanize their pets because of their exposure, and ultimately having to leave their home. I then learned of the work they were doing to raise awareness of the dangers of produced water, and I was also made aware of the wonderful group they were working with called Citizens Caring for the Future. For a year, I thought I was alone in my fear of what oil and gas production was doing to my community, but then I met Penny and Dee and found out how wrong I was. There's actually a lot of incredible advocates down here that are advocating for our community, and I had found a home again. Citizens Caring for the Future hopes that the Oil Conservation Commission will adopt this rule and that in the future additional action will be taken to alert the public of spills and also to clarify how spills are handled and cleaned up. We know firsthand that a lack of clarity has very real life consequences for frontline community members that experience a spill. And we are also grateful the industry is supporting this rule change that will help protect the communities where they produce oil and gas. We believe this is a positive step to help us reach regulatory objectives that will protect us all. Thank you for the opportunity to testify.
Ms. Shoup, you mentioned Penny and Dee O'Coin. Would you please spell those names for the court reporter?
Yes, it's Penny is Penny. Dee is Dee. And then Aucoin is Aucoin.
Thank you. Madam Hearing Officer, I do not have any further questions of Ms. Shoup.
Thank you very much, Mr. Meiklejohn and Ms. Shoup, for your testimony. I have to ask if there are other parties who have questions of you, and the commissioners may also have questions. So, Mr. Ames, do you have questions of Ms. Shoup?
No, Madam Hearing Officer, I do not. Thank you.
Thank you. Mr. Timmons?
No questions for Ms. Shoup.
Thank you. Mr. Cloutier?
No questions, Madam Hearing Officer.
Thank you. Mr. Feldwart?
Likewise, Madam Hearing Officer, no questions.
Thank you. Commissioner Bloom?
Madam Hearing Officer, thank you. Madam Chair, yes, maybe one or two questions for Ms. Shoup. Ms. Shoup, thank you so much for your testimony. You talked movingly about a family that was impacted by a produced water spill and the Aucoin family as well. Have you yourself been impacted or seen produced water spills or other similar spill-related impacts on the environment in your county or Carlsbad area?
I have not been affected personally, and those are the two instances that I have been exposed to or that I have learned of.
Thank you very much.
Thank you. Commissioner Warnell, do you have questions of Ms. Shoup?
I have no questions. Thank you, Ms. Shoup.
Thank you. And Madam Chair?
I just have a quick question. Are you supportive of the rulemaking on the changes?
Yes. Yes.
Thank you.
All right, thank you very much. Mr. Meiklejohn, is there any reason not to excuse Ms. Shoup?
No, Madam Hearing Officer, there is not. Thank you for your testimony, Ms. Shoup.
Yes,
Thank you all.
Thank you both. I want to make sure that that I invite public comment for those who wish to offer it before lunch, and then we really will take a break. This is definitely not your only opportunity to offer that comment. I will ask you to keep that verbal public comment at 3 minutes or less. If you have a lot more to say, I would invite you to put it into writing. The 4 names that I saw this morning, there may have been more rolling in, but the 4 names that I saw earliest were Ralph Rons, if I'm mispronouncing your name, I'm sorry, Liz Klein, Joseph Hernandez, and Gail Evans. So let me ask Mr. Lampkin, do you see Mr. Rons on the platform?
Yes, I do, and I will unmute him right now.
Thank you. Mr.
Good
Rons,
morning.
can you hear me?
This is Ralph Rons, and you all can hear me?
Yes, we can. Thank you very much. Would you like to offer verbal comment at this time?
Would you state your name and spell it for the record, please?
Yes.
will. My name is Ralph Rons. The last name is spelled W-R-O-N-S. I hope that you have the spelling of the first name.
And I did receive written comment, Mr. Rons, from you. I needn't repeat that. It's part of the record already. But if you have something to add, please go ahead.
Thank you. Thank you for the confirmation that you received my written comment. All I will say at this point then is just to reiterate my statement of support for this proposed rule change. And I've been listening to the other testifiers and the questioning, and all I would say at this point is that I'm very much in favor of the discussion and the consideration on financial penalties as a way of ensuring that this proposed rule can be enforced. So I'll leave it at that for now. Thank you.
Thank you very much. Commissioners, in the event you have a question of any public commenter, please let me know. I'm not going to ask each time, if that's okay. Commissioner Bloom, do I understand you have a question?
Madam Hearing Officer, yes. I have not seen Mr. Ron's written contribution. So if that could just make its way to me today, that would be fantastic.
Yes, we received it this morning, and we'll make sure that all of the commissioners get all of the written public comment.
And thank you so much. It's public input.
All right, thank you very much, Mr. Ron. Liz is Klein with us on the platform, Mr. Lamkin. Okay, I definitely call out her name later. What about Joseph Hernandez?
But I think we missed the last name. I didn't hear it.
Oh, Klein. I believe it was K-L.
Oh, okay, sorry about that.
I-N.
Yeah, she's here.
Oh, okay.
Here you go.
Please unmute her.
She's
Madam
unmuted.
Hearing Officer,
Mr. Micklejohn.
I think there's,
Let's see, can everyone hear me?
Oh, yes, I can. Hold on, Ms. Klein.
Okay, great.
Mr. Micklejohn, did you have something to say?
I just wanted to say that I think Mr. Hernandez and we have become a little confused because we intended to present him as one of our witnesses. If he would prefer to make his statement at this time, that's fine with us. But there was a little bit of confusion there.
I'm very sorry, Mr. Micklejohn. I hadn't snapped to the fact that it was the same Joseph Hernandez. I had seen an email communication earlier and mistook him as a public commenter. I would obviously prefer to have him taken in an orderly fashion as part of your case.
Thank you,
but
Madam
thank you for raising that. Let me go back to Ms. Klein. Ms. Klein, would you like to offer a public statement at this moment or wait till later in the day?
I would like to comment now if possible.
Please go ahead. Please go ahead.
Okay. Well, hello, my name is Liz Klein, and that's Klein, K-L-E-I-N. I'm with Three Bear Energy. Three Bear Energy operates natural gas compressor stations and a gas processing plant in Lee County. We also operate produced water recycling ponds where water is received, stored, and piped to other oil and gas companies for reuse. Now, our produced water operations in 2020 saved over 1.5 barrels or 63 million gallons of fresh water. And again, that was from 2020. Three Bear is committed to safe, responsible energy production. We do not oppose the petition to prohibit releases. We support the statements filed by NMOGA and the Independent Petroleum Association of New Mexico. In 2019, the Groundwater Protection Council, a national group of state regulatory agencies, said it considers produced water to be a potential resource rather than a waste. New Mexico oil and gas operators generate 1 billion barrels of produced water each year. Nationally, according to the Groundwater Protection Council, 45% of that is reused. We need to recycle more in New Mexico and avoid wasting this water. The more water we reuse, the less fresh water that will be consumed. And this will benefit all New Mexicans. Produced water can safely be treated and reused, and New Mexico is strengthening its protections. This commission updated its rule in October. The NMED has done outreach on new rules for reuse off the oil field. The Produced Water Research Consortium is developing new technology to capitalize on reuse. We ask you to help New Mexico take advantage of the benefits of produced water. The rules should promote reuse and recycling. Any unnecessary rules, like those proposed by the Sierra Club, can create barriers to managing the water. The commission rejected their proposal, but you will in the future hear more demands for more rules. If future rules make it hard to treat produced water and manage produced water, operators may just inject it because it's easier, which would be a waste. House Bill 546 removed legal obstacles to water reuse. If this commission revisits its produced water rules in the future, please make certain it's feasible for industry to provide produced water as a resource for New Mexico.
Is that all, Ms. Klein?
Yes, that is. Thank you for the opportunity.
Thank you very much. Thank you very much for your comment. Let's turn to the fourth person that I saw this morning who indicated an interest in providing public comment, and then any other public comment we'll take this afternoon. Gail Evans. Is Gail Evans on the platform?
I am
Yeah,
here, but
she's-
I don't wish to make a public statement right now. Thank you.
All right, I'm happy to take your statement later today. In that case, let's take. Well, Madam Chair, what is your pleasure? We've actually made it all the way to 11:30. Would you like to take a lunch break or a shorter break?
Do we know how many public commenters we have that didn't sign up that wish to speak?
Those were the only 4 I've been notified of. Mr. Lamkin, do you have any other information?
There's a couple more that popped up in chat, and I believe that one of them, Castillo Aguilar has 3 or 4 that are going to be making comments from the same platform.
I just want to make sure that I think even if they didn't sign up, we need to make sure to try to get them. And there are a handful of people who are on the line. So I'm not sure how we want to manage that. Maybe if you are an attendee and you want to make a comment, message the host in the chat box.
I think that's what they've been doing.
Okay, great. I'm fine if we want to go ahead and do like a 30-minute, 45-minute lunch break, however long is appropriate, and then come back and do commenters.
All right. So let's break then until 12:15. That's just a slightly short lunch hour, if you will. And when we return, before we take more party witnesses, I will see if there are some folks who'd like to give public comment at that time. But thank you all very much. We're on break until 12:15. All right. Mr. Baca, thumbs up when you're ready. All right, thank you. So when we broke, we had agreed to take some public comment before going to the next party witnesses. And I understand from the.
Can I just have 1 second? I'm just getting my 1 second, Madam Chair. I'm sorry. I'm putting.
Can anyone hear me?
That sounds like you, Mr. Molander.
Awesome. Yeah, I know I've got this addiction to the Bluetooth headsets, which will probably result in me having some unexpected health issue, but I'm always charging them, always playing around with them because they work well for this.
Okay, Madam Chair, I'm ready.
All right, thank you, Mr. Baca. Mr. Molander, anything else?
No, I was just yapping pointlessly to fill the time.
All right. Let's go back on the record then, following a lunch break. When we broke, we agreed to take some public comment before we return to the party witnesses. And the technical host informed me that 2 folks wanting to offer comment and perhaps joined by some students are Castile Aguilar, which is Castille and Bianca, Bianca, Sopoci, Sopoci hyphen Belknap, Belknap. And Ms. Sopoci Belknap, if I mispronounce your name, please correct me when you're on. So do we have Castile Aguilar and Bianca Sopoci Belknap?
Yeah, they're both here.
All right, if you would unmute them, please.
Hi, y'all. This is Castile. I would actually like to let Bianca go first in her testimony, if that's okay.
That's fine. Thank you very much. I will just ask if.
Sorry, I'm ready, but I can't see where I can turn on my camera.
It may not be possible, but we can certainly hear your voice clearly.
Oh, I see that he just made me a panelist.
Right.
So I believe, let me see. Can you all see me now?
I can, yeah, there you are.
Okay, great. Well, good afternoon, everyone. My name is Bianca Sopoci Belknap. I'm the Associate Director of New Energy Economy. So thank you so much for the opportunity to speak this morning. We have several additions we believe should be added to the proposed rule, which we have also emailed for inclusion in the record. I understand that the Oil Conservation Division is obligated to monitor, regulate, control, and enforce against oil and gas pollution to, quote, protect human health and the environment from the effects of development of the state's oil and gas resources. It is New Energy Economy's position that the New Mexico Environmental Department, Energy, Minerals, Natural Resource Department, and Oil Conservation Division are obligated to monitor, supervise, regulate, control, and enforce against oil and gas pollution, but have failed in their fiduciary responsibility to do so. NMED, MNERD, and OCD have failed to issue compliance actions, require remediation plans and complete remediation, restoration, and reclamation requirements, assess penalties, suspend or terminate permits, and have failed to commence civil actions or criminal actions for negligent incidents perpetrated by oil and gas. As a result, the agencies have caused a general atmosphere of impunity for the industry that has proximately caused harm to the people of New Mexico by contaminating our water and land and causing imminent and substantial danger to our health and animals and to the health and welfare of the public. Your official policy of failing to regulate is responsible for the deprivation of New Mexicans' rights protected by the New Mexico Constitution and laws. Much more stringent rules are needed to protect us. And as a quick point of clarification, contrary to the testimony provided by an industry representative earlier, no off-oil-filled rules have been made, for example. But we're here today to talk about releases. And a rule prohibiting releases is absolutely necessary. However, prohibition is meaningless without any required enforcement or penalties. Rules on books that are not enforced are not helpful. We believe that in order to truly protect New Mexicans, the following additions must be made. 1, if the state really wants to prevent spills, we need mandated penalties and enforcement. In addition to adding a no spills provision to 19.15.29.6, you should also change the quote may to a quote shall in 19.15.29.15, which would mean that the division is committed to taking enforcement action for any violations of this section of the rules. 2, when taking enforcement action in order to ensure the penalty is meaningful and a deterrent, the compliance section of the rules should have an addition which reads in 19.15.5.10G, quote, there shall be a rebuttable presumption that any violation of 19.15.29 NMAC presents a risk either to the health or safety of the public or of causing significant environmental harm pursuant to NMSA 70-2-31D, and if not rebutted, shall result in a civil penalty of up to $10,000 per violation per day. 3, rather than just making major spills a violation, please also prohibit minor spills, and please define minor spills to be any spill that is more than 1 barrel. Our communities deserve to be protected against any contamination. Next, in order to ensure that community members who are impacted by the spill know about it, please amend the reporting and notification section of the rule, which is 19.15.29.10, to add a section that says that the responsible party shall notify landowners, residences, institutions, and businesses within 500 feet of the point of release and areas impacted by the release in order to protect human health. And please make the responsible party send the C1 form to all people located or working within a half mile of the point of release. And finally, please add a provision to the rule about releases to make the responsible party collect samples from the point of release and the area that's been impacted so that we can identify what is in the release. Those contaminants should be disclosed to the public, and OCD should have to post that information on its website. That way the community can find out what contaminants they may have been exposed to and take precautions and measures to protect their health. Thank you. Please consider adding these additions to the rule.
Thank you, Ms. Sabochi Belknap. Let's see, Ms. Aguilar?
Hi, I'm wondering if I could also turn my camera on.
Mr.
If that
Lankin?
would be possible.
You should be able to do that now.
Okay, great. Thank you. Let me just, oh, so sorry. Hi, everyone. Thank you for hearing me today. My name is Castile Aguilar, and I'm here as a spokesperson for Yucca. Thank you for the opportunity to speak. I am providing an abbreviated version of our testimony given the time limit on public comments today. However, we have emailed our full testimony for the record. Yucca does not support fracking. We do not believe that the costs to our health, to our environment, and to the millions of people and species already impacted by catastrophic climate change are an acceptable price to pay. The scientific consensus is that we now have just a decade to decarbonize our economy. The effects of climate change are already devastating our food systems, our ecosystems, and our economies. We also know that many of our indigenous and communities of color have had their health sacrificed because of extraction, and that has to stop. It is critical that both industry and our government are accountable when our public health, environment, and futures are threatened. In New Mexico, we know that environmental racism has led to our indigenous and low-income communities of color bearing disproportionate burdens when it comes to the pollution and contamination caused by extractive industry and dirty energy. Some of our members have been directly harmed by living in areas where industry seems to call the shots, and you regulators seem blind to the real and present danger posed by polluters with their daily dumping. We believe the OCD should make it illegal to release produced water intentionally or unintentionally. And we believe the proposed rule must be expanded to require enforcement and penalties for every incident. We support the changes to the proposed rule introduced by New Energy Economy in 19.15.29.15 to change the requirement from may to shall, because regulations should not be optional. We have seen what optional enforcement has brought us. I remind the OCD that under the current language, we see more than 3 spills on average per day. For these same reasons, we support the additional changes proposed for 19.15.5.10G regarding the presumption that releases of produced water present a risk to our health and safety and shall result in civil penalties. There must be consequences when spills, including minor spills, take place. We believe the polluters must be required to collect samples to determine the levels of contamination and release to the public the list of contaminants. And we believe the state must require notification and reporting so that the community in the impacted area is fully informed. The people whose health is at risk certainly have a right to know, and it is the state's duty to protect us. We must transition away from fracking urgently, but as long as it exists, it must be fully regulated. Thank you.
Thank you very much, Ms. Aguilar. And for the transcript, let me note that it appears you are joined by nearly 20 people. Are they members of Yucca?
Yes, and additionally, we do have a few other folks that would like to give a public statement as well, and was told that we could make that happen through this account.
Yes, you can. We do need the full spelling of their first and last name, and if they would keep their remarks brief. Who are you introducing first?
I will introduce Akira Cordova, and I will let them spell their name out for you so I don't mess it up.
Thank you very much.
Hello, my name is Akira Cordova, AKYRA-CORDOVA. Before I begin, I would like to show you something. These are my moccasins. Okay. Hello, my name is Akira Cordova. I'm a member of Yucca, and I stand here for my ancestors, my relatives, and all of these beautiful people in the back. Before I express my thoughts and feelings about fracking and oil and your complacency of our lives in relation to Mother Earth, I'd like to recognize the original caretakers of this land that we are on. I'm in so-called Santa Fe, and we are on Tewa lands. We are all on stolen land. Today I'm here before you in my moccasins. These moccasins were made for me by my auntie for a graduation gift. This is so significant because this is resistance. My grandfather made all of my family moccasins when we were young. Hours of time and hand cramps, eye strains, and careful precision. This is an act of love, intergenerational love, and radical love. Intergenerational knowledge that was supposed to be completely eradicated. We remembered these ways even through the trauma. We always remember in our spirits. Our spirits also remember intergenerational pain, genocide, and colonial lies. I look at my hands and I can feel the tense cold memories breathing the polluted air and drinking the toxic water. Oil pipelines litter our lands. and flood into the clean water, making us sick and suffocating that intergenerational love. We are dying, not just Indigenous people, but all people, Black, Brown, Asian, Muslim, Indigenous, and other marginalized communities experience this firsthand, yet you're suddenly blinded and refuse to accept it. There is no plan B, there is no second option. We are fighting the same fight against colonization as our ancestors did, except now they market it as the oil industry, fracking, or economic growth. What I explained today is nothing you haven't heard before, and yet you're hearing it again, and you will continue to hear it until your waters turn black and your skies are brown. I will leave this meeting with a quote by Russell Means, an AIM leader, an earth protector, and a human rights activist. He said, "Mother Earth will retaliate, the whole environment will retaliate, and the abusers will be eliminated." Thank you.
Thank you, Ms. Cordova. Please state and spell your name.
Okay. Yang, Y-A-N-G. Good afternoon. My name is Yang. I'm Danette and Chicana from the frontline and borderline town Futa, Farmington. I am here speaking as a spokesperson for Yucca, Youth United for Climate Crisis Action. I am a spokesperson and representative of my Indigenous people in the Four Corners region, where our communities and lands have been sacrificed for coal, oil, gas, and uranium for decades. Our lands have been systemically targeted and desecrated for profit before I was born. Dineta, my homeland, was designed an energy sacrifice zone by the Nixon administration in 1973. And since then, my community has experienced detrimental health effects and environmental effects from hundreds of uranium mines, 4 coal plants, hundreds of fracking wells, and the Gold King mine spill in 2015. Back home, oil and gas waste is polluting our precious water, air, and land. Legislators and industries that contaminate the land and don't clean up their mess should not just pay a fine. They should be held accountable for the deaths of the frontline communities and the contamination of the land. The leadership of our state and our Navajo Nation has forgotten their duty to protect the people and the environment. Instead, they protect the industries and oil and gas companies. Our Indigenous communities and BIPOC frontline communities have had their health sacrificed because of fracking and the state's failure to regulate, and that has got to end now. This risky approach of extraction and consumption powers gentrified cities, which allows those with wealth to continue to colonize for their conveniences and luxuries of a modern life. But back home, on my reservation, it means living beside oil and gas barrels and fracking wells. It means breathing in your hate for the earth and community. You know we don't have the same luxuries as any of you or your children, but soon all of us will all begin to have plenty of asthma, cancer, and lung disease. If you do not hold these industries accountable for the mess that they are making, there is no reason for you to be a representative if all you do is contaminate the earth and kill communities. You are regulators. You have the power to make change. This rule is one way to begin to start regulating and begin to do the right thing. We demand that it be strengthened. I see the vision of a clean value with a healthy community, clean air, water, and environment, and a thriving wildlife. This is the future all of us are all fighting for. Help make this a reality. Ahiahet. Thank you.
Thank you, Yang. Is there anyone else?
We have 2 more young folks. Alex, if you'd like to start.
Please state and spell your name.
Alex Hanna, ALEXHANNA. Hi, I'm Alex, and I'm here with Yucca. I support the proposal rules to prohibit oil and gas industry spills in New Mexico. They are the first step to protect people and the environment and hold the oil and gas industry accountable. This is environmental racism and is disproportionately impacts on indigenous and frontline communities. It is unfair that these people have to suffer because of who they are. In the Permian and San Juan Basin, the leading cause of death is cancer. These people are literally dying, and it is still legal for the oil and gas industries to spill toxic waste in New Mexico. This is shocking, and we need to change this. Change this for the community suffering. Change this for the people on the front lines. Change this for the land of enchantment. Thank you.
Thank you, Mr. Hanna. Is there anyone else?
I'm Adrian Hanna, ADRIANHANNA. Adrian, go ahead and take off your mask. Thank you for letting me speak today. My name is Adrian Hanna. I'm here with Yucca. Produced water is radioactive. Toxic waste is dangerous, contaminating our water, killing wildlife, and scarring the great land of enchantment. Water is life. We can't contaminate water. We can't contaminate life. I've been down to Artesia. After 1 hour of being there, my throat was sore, and I had a headache. In my ear was a constant buzz. I saw people suffering from pain and sadness because of fracking. Toxic waste spills have already caused harm to the land, to the communities, and to our water. There are places into New Mexico where you can't go because of fracking spills. There are communities torn apart because of fracking spills. There's water not safe to go into because of fracking spills. It should be illegal to scar Mother Earth. It should be illegal to put poisonous fracking waste into Mother Earth. It should be illegal to kill the wildlife it took nature thousands of years to create. I support the proposed rule to prohibit oil and gas spills, to take this first step to a safer land of enchantment, to hold the oil and gas industry accountable for the harm they've done. These rules are not enough. All spills should be illegal. We need to transition away from these industries that threaten our health, environment, and future. We need a transition away from the industries poisoning our water, our communities, and our land of enchantment. Thank you.
Thank you, Mr. Hanna. Is there anyone else, Ms. Aguilar?
No, thank you so much for hearing the youth's testimony today and giving us the time to voice our concerns.
Thank you so much. You have a great group of thoughtful, well-spoken students. Thank you. If there's anyone else on the platform who would like to offer public comment at this time, this is not the last opportunity. I'll ask again a few more times this afternoon. But if you would like to offer public comment now, please reach out to the technical host and let him know that you would like to offer comment now. Mr. Lamkin, do we have any interest?
I haven't received anything else yet.
Ms. Orth, if I might.
Oh, Commissioner Bloom.
Yeah, Madam Hearing Officer, thank you, Madam Chair. Hey, I just wanted to also thank our young people here today, Adrian, Alex, Yang, and Akira for coming and speaking to us. I think it's great that people are taking a role and being active in regulation and obviously care greatly about our environment. And I just briefly wanted to say to Castile and Ms. Castile Aguilar and Ms. Bianca Posi Belknap, that the additions that they want to see and support are the same or very similar to the ones that were presented to us recently by the Sierra Club and other interveners. And while we are not taking those up during this hearing, based on what we heard last week from the interveners, and I'm sure Mr. Micklejohn could speak to this, I believe will be a petition in the near future prompting those very changes, and we may be hearing that in the near future. So I just wanted to address that while they were all still on the line. Thank you.
Thank you, Commissioner Bloom. Mr. Lamkin, any interest yet, or shall we turn to a few party witnesses?
Hello, this is Gail Evans. Can you hear me?
Oh, yes, I can, Ms. Evans. Whenever
still
you're ready.
learning.
Oh, first spell your name and then make your statement.
And I don't know if you can see me. I don't know if it matters. It says my video is.
I cannot see you.
It says my video is disabled, but
Hang on one
yeah,
second.
my name.
I can make you a.
Hold on, Ms. Evans. I believe Mr. Lamkin is working on giving you permission.
Okay, you should be able to now.
Okay, thank you. My name is Gail Evans. I am a constitutional rights attorney here in Albuquerque.
Would you spell your name, please?
GailEvans. And I wanted to bring to everybody's attention a section of our state constitution that applies to this hearing. And it's Article 20, Section 21 of the Constitution. And it reads, "The protection of the state's beautiful and healthful environment is hereby declared to be of fundamental importance to the public interest, health, safety, and the general welfare. The legislature shall provide for control of pollution and control of despoilment of the air, water, and other natural resources of the state, consistent with the use and development of these resources for the maximum benefit of the people." So the legislature passed the Oil and Gas Act, which gives the OCD the opportunity to regulate the oil and gas industry. It's disappointing that the Oil and Gas Act doesn't mandate regulation of the oil and gas industry. In fact, it should, but it gives this division and this commission the opportunity to regulate the Oil and Gas Act, to regulate the industry. And today you have the opportunity to take a stance against spills, not simply by saying they're prohibited, because prohibiting something without enforcing that rule is meaningless. And today you have the opportunity to change 19.15.29.15 to say that you shall take enforcement action for any violations of this spills rule. And I understand that you're saying you're going to take up some matters on another day, but not ensuring enforcement of this rule leaves today's hearing to be meaningless and doesn't address the concerns that are intended to be addressed and that are so needed to be addressed as spoken by the members of Yucca. So I am requesting that you change the may to a shall, and that you put the oil and gas industry on notice that if they spill, there shall be enforcement by your division. And if the division needs more funding to do that enforcement, which you made clear at the last legislative session and other sessions, then to please go and seek that funding in a very and not behind supposed budgetary constraints. We have choices. We make choices about how we spend our state money, and more state money needs to be spent on enforcement. Thank you.
Thank you very much, Ms. Evans. Well, let me ask if there's anyone else on the platform at this time who would like to offer public comment. This is not the final opportunity in this hearing. please reach out to the technical host if you'd like to offer that comment now. Mr. Lamkin?
Nobody's said anything.
All right, we're going to turn then to the next party witnesses, which will be presented by Mr. Micklejohn on behalf of the environmental groups known as interveners. After a while, we will take another break, and I will ask again if there's additional public comment. So, Mr. Micklejohn.
Thank you, Madam Hearing Officer, Commission members. Our next witness is Camilla Feibelman. I don't see her name on the platform.
I think I saw it earlier, but let's.
She's a panelist now.
She's a panelist now, Mr. Micklejohn.
Okay, can you hear me all right?
Oh, I can. And now I can see you as well. Would you raise your right hand, please?
Sure.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And
would you
spell your name?
Would you
Yes.
please state your full name and your address?
Yes, it's Camilla Feibelman. That's spelled Camilla. The last name is Feibelman. F as in Frank, E-I, B as in boy, E-L-M-A-N. And my address is 2215 Lead Avenue, Southeast, Albuquerque, New Mexico, 87106.
Would you please describe for us your education and background?
Yes, I am the director of the Rio Grande chapter of the Sierra Club, and that's a position I've held since May of 2013. I have a master's degree in planning from the University of Puerto Rico and an undergraduate degree in environmental biology from Columbia University in New York. Maybe most importantly, I graduated from Albuquerque High School, where I founded my first environmental club. I was a Fulbright Scholar in Peru, and I serve as a trustee for the Udall Foundation at the nomination of President Obama, confirmed by the Senate. And I've been employed by the Sierra Club since 2000 and had a variety of positions and participated in multiple technical rulemakings on topics of environmental quality and protection.
Have you prepared a statement for the commission today?
I have.
Would you please provide that?
Sure. Yeah, I am testifying on behalf of the Rio Grande chapter of the Sierra Club, which is a volunteer-led organization representing more than 35,000 members and supporters in New Mexico and West Texas. Our mission is to explore, enjoy, and protect the planet. Our Rio Grande chapter prioritizes protecting climate, air, water, wildlife, and public lands in New Mexico and Texas. And because of those interests, we're particularly interested in protecting New Mexico's precious water resources and therefore have a significant interest in this proceeding. Effective regulation of the oil and gas industry and addressing the impacts that industry has on people and our environment are top priorities for us. The rule changes proposed by Wild Earth Guardians and the division would prohibit major and minor releases of oil, gas, produced water, and oil field wastes that are collectively referred to as releases, thereby addressing one important source of the oil and gas industry's impact on people and the environment. The Sierra Club strongly supports the change to the commission rules proposed by Guardians and the division. The current commission rules do not actually prohibit releases of oil and gas or oil and gas waste, and that, from our point of view, is a serious problem with the current rules. The Sierra Club and its members are grateful to Wild Earth Guardians, who initially brought this proposed rule change to the commission, and that OCD concurred that a prohibition of spills is needed, and therefore they filed this joint petition that's before you today. And we really think that this type of collaborative rulemaking is key to moving forward to protect air, water, and other aspects of our environment. The proposed modification to prohibit releases will strengthen the rules governing releases and give OCD the much needed enforcement authority to protect public health, the environment, and freshwater resources. As stated by OCD and Wild Earth Guardians in the joint rulemaking proposal, operators should not release oil and gas, produced water, and other contaminants in the first place, and the division should be given the tools necessary to prevent those releases. But in that context, I would like to recognize OCD's need for funding, staffing, and overall limited resources to adequately implement and enforce this rule, as well as other rules. We shouldn't spend resources on permitting industry without the proper capacity to inspect and enforce and protect our people, air, water, and climate. Thank you for the opportunity to express our concerns about ongoing releases of oil, gas, produced water, and other oil field wastes, and to voice our strong support for the proposed modifications to the rules that govern releases from oil and gas facilities to prohibit releases. Thank you.
Madam Hearing Officer, I have one follow-up question. Ms. Feibelman, has the Sierra Club in the past worked to support efforts by the New Mexico Energy, Minerals, and Natural Resources Department to get more funding for its various jobs that it has to do? Has the Sierra Club supported that in the state legislature?
We have, and I'll preface my answer by saying, and I should have said this in my statement, you know, we are really grateful to the public servants on this call, the commissioners, the members of the staff of these agencies who, you know, are really bearing the impact of reduced budgets from previous years and past administrations. And so, if I can say it in a colloquial way, we know you're doing the Lord's work for us. And at the same time, we need to ensure that the legislature provides, as is their constitutional duty, for budgets that protect our communities. And for that reason, we actively, openly, and publicly advocate for reasonable budgets for our environmental agencies.
Thank you, Ms. Feibelman. I do not have any other questions.
All right. Thank you, Mr. Meiklejohn and Ms. Feibelman. Mr. Ames, do you have any questions?
Ms. Orth, thank you. We appreciate Ms. Feibelman's testimony, but we have no questions. Thank you.
Thank you. Mr. Timmons, any questions?
No questions for Ms. Feibelman today. Thank you.
Thank you. Mr. Cloutier?
Madam Hearing Officer, we have no questions for Ms. Feibelman. Pardon me, I had a scratch in my throat.
Thank you. Mr. Feldowart?
Thank you, Madam Hearing Officer. No questions.
All right. Commissioner Bloom, any questions of Ms. Feibelman?
Ms. Feibelman, thank you for your testimony today and contributions, and no questions at this time.
All right, thank you. Commissioner Warnell.
Madam Hearing Officer, I have no questions at this time. Thank you.
Thank you. Madam Chair.
Let's have one brief question. Are you supportive of this rulemaking petition?
Very much.
Thank you.
Okay, thank you very much for your testimony, Ms. Feibelman. And Mr. Meiklejohn, we will excuse Ms. Feibelman.
Thank you, Madam Hearing Officer. Our next witness is Julia Bernal.
Oh, I see Ms. Bernal there on the screen. If you would please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Thank you, Ms. Bernal. Would you please state your name and spell your name for the court reporter?
Yes, Julia Bernal, Juliaberbernal.
And have you prepared a statement for the Oil Conservation Commission for today's hearing?
Yes, I have.
Would you please go ahead and provide that to the commission?
Yes, thank you. Makwam, my name is Julia Bernal. I am the current director of Pueblo Action Alliance. We are a community organization that addresses environmental and social injustices that occur on our ancestral indigenous landscapes. We are a women and youth-led organization that addresses issues like the fossil fuel industry, the federal fossil fuel leasing programs, climate adaptation and mitigation, and also addressing the economic impacts of extractive industries that we believe are desecrating our cultural integrity. We have been providing our expertise and grassroots experience to the Frack Off Chaco Coalition that addresses, again, the federal fossil fuel leasing programs, particularly in the San Juan Basin, otherwise known as the Greater Chaco region. This place is significant in its spiritual and cultural importance to the 20 Pueblo nations in the Southwest. I myself am from Sandia, so have a personal investment as well. And we have been addressing these issues pertaining to the basin for years. As mentioned before, I've been serving for Pueblo Action Alliance for the past 5 years, but have previous experience in the water resources sector. For the past 7 years, I've been working in many capacities within the water resources sector, whether that's technician, data collector, educator, and now a graduate student and research assistant at the University of New Mexico. In my experience over the years, I have an understanding of how a typical fracking well works, the consumption of water and the waste this type of extractive operation produces. And produced water should be treated in a manner that holds the industry accountable for the releases that are exposed or that are potentially exposed to the natural landscape. And this particular type of release could be extremely harmful to the environment, its ecosystems, public health, and clean water. I myself and Pueblo Action Alliance do support the amendment of the Oil Conservancy Commission's regulations that would prohibit releases, but I would also ask that the commission engage in its 2020 Tribal Collaboration Act with the sovereign nations of New Mexico on any rulemaking processes. I also want to point out that as indigenous people to this landscape, we hold our ancestral homelands as the #1 priority in terms of protection and stewardship. Also, those who have settled and lived in New Mexico also have taken stances to protect public lands and other cultural landscapes that make the state unique, beautiful, and cultural. So strengthening rules to protect the landscape and its people should also be a top priority, and enforce the oil and gas industries to also help to protect the landscape, whether they have vested interest or stake in our lands. I hope the commission considers the long-term impacts that produced water can have on our lands, waters, and people. Thank you. Herkim.
Thank you, Ms. Bernal. I have one follow-up question. Do you support the proposed change to the regulations that's been advocated by Wild Earth Guardians and the Oil Conservation Division?
Yes, I do.
Thank you. I have no further questions.
Thank you, Mr. Meiklejohn and Ms. Bernal. Mr. Ames, do you have any questions of Ms. Bernal?
We appreciate Ms. Bernal's testimony. I have no questions for her. Thank you.
Thank you. Mr. Timmons?
I echo the sentiment of Mr. Ames and have no questions. Thank you.
Thank you. Mr. Cloutier?
No questions for Ms. Bernal. Thank you.
Thank you, Mr. Felderwerk.
Madam Hearing Officer, no questions. Thank you.
Thank you. Commissioner Bloom?
Ms. Bernal, thank you for your testimony today. I greatly appreciate it. No questions.
Thank you. Commissioner Warnell.
I have no questions. Thank you for your support, Ms. Bernal.
Thank you. And Madam Chair.
Mr. Micklejohn got ahead of me, so I have no questions. Thank you for
All
your
right.
time.
Thank you so much, Ms. Bernal, for your testimony.
Thank you.
Mr. Micklejohn will excuse Ms. Bernal at this time.
That's fine. Our next witness is Norman Gaum.
Right. Let's see. Oh, there you are, Mr. Gaum. Would you raise your right hand, please? Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much.
Would you state and spell your full name, please?
My name is Norman Gaum, Normgaume.
And what's your address, Mr. Gaum?
I reside in rural Sandoval County, New Mexico.
Could you outline for us your background?
I'm a retired licensed professional water engineer. I was educated at Hobbs High School and New Mexico State University, where I earned a Bachelor of Science in Electrical Engineering and a Master of Science in Civil Engineering degrees. All my professional employment in New Mexico over 37 years, from 1978 through 2014, required a New Mexico professional engineering license. I have professional experience in water and wastewater facilities management, design, construction, operations and maintenance, and in water resources management, planning, and administration. My graduate work included 8 graduate hours in statistical analysis and models of data.
Did we submit with our notice of intent to present testimony a resume of your qualifications?
Yes.
Is that resume accurate?
Yes, it is.
What is your interest in this proceeding?
I'm participating in this hearing to support the joint proposal to prohibit spills in order to protect human health, the environment, and freshwater resources. I'm interested because spills are currently okay. There's nothing prohibited or illegal about them. Enormous volumes of oil and gas industry toxic and highly saline liquid oil fill waste and other materials are released. Spills occur frequently, about 3.5 liquid spills per day in 2020. Oil Conservation Division data show that some operators do a much better job in preventing spills than other operators. My testimony will elaborate on why the proposed rule is critical.
Would you explain, please, your experience and background on water issues in New Mexico and on oil, gas, produced water, and other oil field waste issues?
Yes, thank you. I served as director of the New Mexico Interstate Stream Commission for 6 years. I personally engaged with stakeholders to negotiate and prepare an effective agreed plan for compliance with the 1987 United States Supreme Court amended decree, which required that New Mexico never again owe water to the state of Texas on the Pecos River. The principals were Carlsbad and Roswell irrigation districts, the Bureau of Reclamation, and numerous agricultural and municipal users. Our plan was authorized by state law, was implemented, and has proven to be successful. I understand the surface water issues on the Pecos River. I've addressed water resources controversies in many other areas of New Mexico. I've been retained as a consultant on a variety of water resources planning and management and water rights issues by 3 state agencies, a university, 2 large water purveyors, and 2 environmental advocacy groups. I was selected on the basis of my professional qualifications to serve on the New Mexico Produced Water Research Consortium's Technical Steering Committee. I have devoted many hours since the beginning of 2020 to research Oil Conservation Division data and perform analysis regarding produced water and spills.
The proposed rule, that is the rule proposed by the division and Wild Earth Guardians refers to releases. You referred to spills. What are spills?
The Oil Conservation Division statistics webpage lists various files and databases that can be downloaded. Incidents and spills, parentheses, search and listing, close parentheses, end quote, is the name of the Oil Conservation Division file that contains thousands of records pertaining to releases. When the spills and incidents data is searched and the selected records are downloaded, they appear in an Excel file entitled Spills. I have downloaded and analyzed some aspects of the most recent of these thousands of spill records since 2017.
Have you reviewed the technical testimony that was provided earlier in this hearing by Jim Griswold?
Yes, I found it very useful.
Do you agree with part or all of it?
I do agree. Further, I'm really pleased to see this rulemaking occur. It's a very significant initiative that has been needed for many years, as Mr. Griswold's expert testimony makes clear. The joint rulemaking proposal of the Oil Conservation Division and the Wild Earth Guardians makes clear the critical need for this rulemaking proposal to be approved. It says in part, after the fact reporting and cleanup obligations standing alone are inadequate to protect public health and the environment. Operators should not release oil, gas, produced water, and other contaminants in the first place, and the division should be given the tools necessary to prevent those releases. I wholeheartedly agree with that statement. Much remains to be done to truly stop preventable spills. Prohibiting spills is the first essential but insufficient step.
Have you conducted research regarding produced water and oil and gas industry spills?
Yes, I have, and my research continues. I'm seeking to understand Oil Conservation Division public data, the information it provides, and its deficiencies. In preparation for an Oil Conservation Commission rulemaking hearing in 2020, I downloaded and reviewed 2019 spills data. I found that more than half of the produced water spills were self-reported by 4 operators: XTO Energy, COG Operating, Devon Energy, and Oxy USA. The vast majority of those spills were reportedly due to causes that, in my professional opinion, are preventable and or negligent. I offer those conclusions drawn from Oil Conservation Division data and my opinions regarding preventable and negligent spills in my testimony before this commission last year. For this hearing, I reviewed 2020 spills. I summarized my findings in my written testimony offered in support of the proposed rule. I also felt the need to calculate a directly comparable rate of produced water spills for each registered operator. Using Oil Conservation Division data, I calculated each operator's normalized rate of spills by dividing each operator's numbers of self-reported produced water releases divided by the million barrels of oil equivalents they produced. My analysis relied on 4 different Oil Conservation Division files, 3 for annual production in each year, 2017 through 2019, and the number of release records with material spilled equal to produced water for those 3 years. My analysis shows there is a wide variance in normalized produced water spill rates by both larger and smaller operators. I will explain with examples, and I'd like to show a table on your screens to illustrate these changes. This table compares the normalized spill rates and the relative frequency of spills of the largest New Mexico energy producers with the 4 operators that reported more than half of the produced water release incidences in 2019. The table is contained in my written technical testimony. Am I allowed, Madam Chair, Madam Hearing Officer, to share my screen?
Yes, Mr. Lamkin, if you would make that so.
You should be able to.
Please try it, Mr. Call.
Well, I'm having a technical difficulty. I had to re-download my WebEx software for this meeting, and now my my permissions are messed up. Just a moment, please. So it says I am the presenter, but my share screen box at the bottom of my window is still grayed out. Rather than take your time to sort through these technical problems, I will just describe the table for you and refer you to it's the same table that appears in my written testimony submitted earlier.
Thank you.
So this table compares the spill rates and energy production of 5 operators. I chose EOG Resources because they have produced the most energy of all the New Mexico operators for the time period I looked at, 2017 through 2019. The other 4 operators I selected for this comparison are the 4 operators that together were responsible for more than half of the produced water spills in 2019. And these data again are for 2017 through 2019. And those operators are XTO Energy, COG Operating, Devon Energy, and Oxy US. Going from memory, XTO Resources is the largest energy producer. I believe COG Operating is the second. I believe Devon Energy is the 4th. Oxy USA is 10th. I may have that wrong. I think XTO Energy is maybe the 10th. EOG Resources experienced or reported 43 spills over the produced water spills over the period from 2017 through 2019. And when you divide that number of spills into the million barrels of oil equivalents that they reported producing, they have a normalized spill rate of 0.26. XTO Energy reported 211 spills over the 3-year time period. And dividing that by the million barrels of oil equivalents they produce gives them a normal spill rate of 5.12, which is 20 times higher than the spill rate per million barrels of energy produced by EOG Resources. Similarly, COG Operating reported 342 spills, Devon Energy 270 spills, Oxy USA 199 spills, and those number of spills divided by the amount of energy they produced are 9.6, 9.9, and 8.0 times. Those are the multipliers with regard to the performance of EOG Resources, which I used as a benchmark for that study. And what this indicates to me, and I have confirmed it through conversations with an employee of EOG Resources, is that spill control in New Mexico is currently voluntary. Some operators choose to spend money and invest in facilities and training and automation to prevent spills, and other operators, having no mandate, choose not to spend that money. Prohibition of spills is the first step in leveling the playing field between operators for the benefit of New Mexicans. I was asked to describe my research. That summarizes one piece of it. I also want to say that I'm seeking to understand what the data shows by performing compilations of public data and comparisons that the Oil Conservation Division should, in my professional opinion, prepare and make public. I'm also seeking to understand deficiencies in the Oil Conservation Division's public data, and I have many unanswered questions. My colleague Peter Coe and I have met once with Jim Griswold regarding questions. It was very useful conversation. I have submitted in writing specific questions and have asked for a meeting to discuss them, but our schedules have not been compatible since I posed the questions a couple of months ago. And I have compared what I know about Oil Conservation Division data with public data quality implementation standards pursuant to the New Mexico Water Data Act of 2019, which names the Oil Conservation Division as a directing agency.
In your professional opinion, Mr. Gum, why are spills a problem? And why do you support the proposed rule to prohibit spills?
As Mr. Griswold's written technical testimony demonstrates, the Oil Conservation Division and the Oil Conservation Commission have not used their statutory discretionary regulatory authorities to date to prohibit spills and to cause operators to prevent them, thereby protecting the public health, the environment, and freshwater resources from huge volumes of oil industry products, chemicals, and liquid waste that are spilled onto the surface of the earth. Registered oil and gas operators reported they spilled 26.5 acre-feet of toxic materials in 2020. And I put the volume into units that I think make more sense to people than maybe reporting that same volume as almost 9 million gallons. The amount of spill volumes, the total volume self-reported by operators, would have covered 26.5 acres, 1 foot deep, in these toxic and highly saline wastes and other oil products and chemicals. Of the 1,543 spills and releases that were self-reported by oil and gas operators in 2020, 1,294 were not natural gas releases. These spills, an average of 3.5 a day in 2020, are currently allowed but would not be under the Wild Earth Guardians and Oil Conservation Division jointly proposed amendments to the Oil Conservation Commission's release rule. Preventable causes labeled equipment failure, corrosion, human error, overflows of storage tanks and pits, and normal operations caused over 1,000 or 82% of these self-reported spills. The total volume reported of these spills, as I said, was 26.5 acre-feet. But the actual total spill volume is likely higher because 404 of the 1,259 release incidents that were not natural gas were reported to have spilled 0 barrels, even though 208 of those 0 volume spills were self-reported as having major severity. 40 additional spills that were reported as having a spill volume of 0 also had a blank in the severity column of the Oil Conservation Division's data. Oil Conservation Division data and personal communications with industry managers demonstrate that prevention of spills is currently voluntary. Some operators invest to control their spills, others don't. Exhibit 3 which depicts Oil Conservation Division data regarding spills and productions, demonstrates that fact.
When you refer to Exhibit 3, are you talking about the Exhibit 3 that was submitted as part of our notice of intent to present testimony in this proceeding?
Yes, that was my reference.
And does that accurately reflect OCD, I beg your pardon, division data and your analysis of it?
It does.
Madam Chair or members of the commission, hearing officer, I would object at this point in time to Mr. Gom's discussion and verification of the analysis that he has purported to pre-file in advance of this hearing, because as I understand it, that is based solely on the quote-unquote workbook that he put together that has been excluded because it was not timely and properly provided to the parties so that they could analyze this information. So to the extent that he's going into that data any further and offering and referencing any exhibits, that would be appropriate, or that is appropriate, not appropriate.
All right, thank you, Mr. Feldewart. As I was listening, it occurred to me that perhaps he was speaking more to the information on the OCD webpage and not necessarily the workbook. Let me ask Mr. Ames, do you want to share in the objection, or do you have any observations here?
Thank you, Madam Hearing Officer. It's a close question, but I think I need to support Mr. Feldewart. My understanding from the order is that the workbook was excluded. The workbook is the basis for the summaries and conclusions in Mr. Gom's testimony. He's essentially been testifying to those summaries and conclusions without referencing the workbook explicitly. So I've refrained to this point, but I think we've now heard virtually all of Mr. Gom's testimony, and I think it may be appropriate to bring it to a close.
All right, thank you. Mr. Timmons, any other observations here?
If I can find them, you but no questions for me.
All right, and Mr. Cloutier, any comments on this objection?
IPA&M joins in Mr. Feldewart's objection. Thank you.
All right, thank you. Mr. Meiklejohn, your response, please.
Thank you, Madam Hearing Officer. I believe that Mr. Gom would testify that what he's talking about is based on the data and not necessarily the compilation of that data in the workbook. We understand that the workbook has been excluded from evidence, but that does not mean that the data that were gathered for purposes of the workbook also has to be excluded.
All right, thank you. That was kind of what was happening in my head as I was listening to Mr. Gom. Can I please clarify one other thing while I have you, Mr. Meiklejohn? I'm looking at the NOI, at your NOI, and Exhibit 3 is Mr. Gom's resume. Exhibit 4 is his statement. And a few moments ago, it sounded as though he was referring to an Exhibit 3 that maybe didn't jive with my copy of the NOI.
Madam Hearing Officer, I apologize for the confusion. The Exhibit 3 that Mr. Gom was referencing was what's labeled as Exhibit 3 in his testimony on page 12 of his pre-filed testimony.
Yeah,
that's
okay.
That's my error, and I apologize for that.
No, I'm sorry. I just wanted to be clear on the transcript. When he was speaking to Exhibit 3, he was speaking to a table, really, labeled Exhibit 3, which appears on page 12 of Exhibit 4. Okay. So let me ask you, Mr. Micklejohn, I guess consistent with what Mr. Ames just said, I feel like we have heard Mr. Gom's conclusions, that is to say, the testimony he wanted to give. What else was he going to speak to coming up here? Is there anything else?
Yes, Madam Hearing Officer. Mr. Gom is prepared to speak to whether spills are preventable and whether there is a need for protection of public health, the environment, and fresh water in an organized manner rather than the current piecemeal approach by several different agencies that is the current situation.
So will there be additional testimony that would flirt with that line there between the workbook and OCD's data generally?
I don't believe that the Exhibit 3 is a part of the points that I just mentioned. There is one other point, and that is, why is control of water pollution particularly important in New Mexico?
Okay. Mr. Felderword, anything else on that? I'd like to, I mean, you understood the distinction I was trying to make there.
Yeah, and if I may comment on that, I understand the distinction. I can only go by what Mr. Gom has provided with respect to how he put this information together and what he intended to provide, okay? When you look at his written testimony, which they've marked as Exhibit 4, on page 3, he discusses the Exhibits 2 and 3 that are attached to his testimony. He states in each one of the, for each of those circumstances, that it is based on the data in Exhibit 1, which is the excluded workbook. In fact, he says these are graphs that are also depicted in Exhibit 1. So I don't know how, given the fact that the workbook has been excluded and the fact that these exhibits that he intends to reference and discuss are based upon the data that is in that workbook, I don't know how he can now move forward and discuss these additional exhibits when the public has not had an opportunity to examine the data that he has chosen to rely upon to put these together.
All right. Thank you for that. So, Mr. Micklejohn, obviously the pre-filed testimony is in the larger documentary record for this rulemaking, but as to charts or tables that are based on a workbook that was excluded, for now they're going to have the status of an offer of proof, and the commission will have to weigh whatever weight they want to give them as part of their deliberations. So if you would please move on to the other two topics that you said Mr. Grom would be addressing.
Mr. Gom, in your professional opinion, are spills preventable?
My experience as a professional engineer managing water and wastewater facilities, rehabilitation, operations, and maintenance is the basis for my professional opinion that the vast majority of spills are preventable. Equipment failure indicates the equipment was not designed to operate without failure under foreseeable conditions, or has not been maintained adequately or replaced with sufficient frequency. Corrosion indicates that equipment and facilities materials were not selected to withstand the highly corrosive conditions that are to be expected when handling highly corrosive liquid oil fill wastes, or that investments to maintain or replace equipment were not made to prevent corrosion failures. Human error indicates the responsible human was not properly trained or supervised, or was expected to perform tasks that could be automated with superior reliability. Flows of tanks and pits is negligent. The fact that normal operations is the cause for spills indicates the commission and the division have been willing to accept spills as normal.
Mr. Gum, in your opinion, does the state of New Mexico currently have an organized or a piecemeal approach to regulating spills and protecting public health and the environment?
Objection. I'm objecting to the potential based on Mr. Micklejohn's previous representation regarding this topic. Then Mr. Gom is going to testify regarding regulatory schemes implemented by other agencies in the state of New Mexico and compare them, contrast them to what OCD is doing. There is nothing in the pre-hearing statement or in Mr. Gom's pre-filed testimony regarding the regulatory schemes of other agencies to regulate releases. And it's also irrelevant to the topic of the petition, which is to prohibit major and minor releases under OCD's rules. I think the testimony would be very interesting to hear, but it's not appropriate and has not been properly noticed.
All right. Mr. Micklejohn, that objection sounds like a solid one to me.
Madam Hearing Officer, it's relevant to the issue of how the Oil Conservation Commission and the Oil Conservation Division go about regulating spills and protecting public health, the environment, and fresh water. It's relevant to the need for that effort to be a much more coordinated and organized effort than it currently is.
So I understand, and if you've got a foundation that Mr. Gom can speak to OCD's efforts or scheme, that's fine. But to go to Mr. Ames's point, I don't think it needs to be a comparison with other agencies when that testimony was not noticed up.
So, Mr. Gum, in terms of the commission and the division's efforts to regulate spills and protect public health, the environment, and fresh water, is your opinion that the approach used by the commission and the division has been a coordinated, organized approach?
No, my opinion is that it has been piecemeal. And I would like to describe the dilemma that interveners find themselves in. It was mentioned earlier that we might petition to have the three minor changes, the changes that we characterized as minor, be the subject of a rulemaking. We could petition to have those heard, but there are many other issues that need to be heard. The interveners are concerned that if we were to file a petition to add those three minor things, that a year might elapse, as has been the case with, or almost a year, the petition to prohibit spills. We would prefer to know the Oil Conservation Division's and the Oil Conservation Commission's regulatory plan. We would prefer to participate in an open collaborative process, but we've not been invited to do that, and we're unaware of plans that we've heard Oil Conservation Division staff mention, but not describe in any detail or provide to us.
In your professional opinion, Mr. Gum, why is control of pollution of water resources particularly important in New Mexico?
Well, the public has a constitutional right adopted in 1971 by a vote of the people. And you've already heard in a public comment that testimony, or rather that the constitutional provision was read to you. I think it is particularly important, and I don't think that control of pollution from the oil and gas industry, it's far from regulated and controlled. And the despoilment of the air, water, and other natural resources of this beautiful state have been substantially compromised by this uncontrolled pollution. I am a water engineer. I have worked my career to try to protect clean water and see that it's available for all of the uses that we depend on for our existence here in New Mexico. Water pollution control is particularly important here. We are the driest, most arid of the 50 states. Our groundwater resources are all we have in Southeast New Mexico other than the Pecos River, where senior water rights and compact delivery requirements to the state line require more water than the Pecos River provides. Groundwater resources, including brackish water protected by state law, are the only water resource available for Southeast New Mexico's future. The Ogallala Aquifer has been nearly depleted. We need to preserve the quality of the water remaining for the use of younger and future generations. We also need to prohibit the waste of water. The state engineer recently suspended new permit applications for groundwater pumping in Southeast New Mexico, which is an indication of how precious it is. In the San Juan Basin, shallow groundwater, which is particularly vulnerable to toxic and salt pollution from spills, is the drinking water source for tribal communities.
Thank you, Mr. Gum. I don't have any further questions.
Thank you, Mr. Meiklejohn and Mr. Gom. Mr. Ames, do you have questions of Mr. Gom?
Just a couple, please. Mr. Gom, you testified that the Sierra Club was not invited to participate in the development of these proposed changes. Isn't that right?
Yes.
You're aware then that the Sierra Club proposed additional amendments to Part 29 to OCD about 4 weeks ago?
Yes.
And you're aware that OCD told the Sierra Club that if it wanted to propose additional changes, they should present it to all the parties who are presently in this hearing, including our co-petitioner Wild Earth Guardians and the 2 trade associations. Isn't that right?
Yes.
Thank you. Nothing further.
Okay, thank you, Mr. Ames. Mr. Timmons, do you have questions of Mr. Gom?
No questions for Mr. Gom. Thank you.
Thank you. Mr. Cloutier?
Just one follow-up on Mr. Ames's questions. Mr. Gom, you're aware that Sierra Club, after the division's invitation to share with my client and the other industry association present here, that Sierra Club elected not to do so until the deadline for filing its pre-hearing statement of May 26, correct?
That is correct. And there was a reason for that. There were only days left before the deadline for written testimony to be submitted.
No further questions.
Okay, thank you. Mr. Feldowert, do you have any questions of Mr. Gom?
I do. My initial question, though, is I'm assuming, Madam Hearing Officer, that Mr. Gom's Exhibit 4 will not be part of the record, as it should not be, since it was not offered.
Right. So,
Okay.
Mr. Meiklejohn, would you like to offer 3 and talk about the status of 4? What would you like to do?
I'm sorry, I'm not sure what the reference exhibit, what is referred to by Exhibit 4.
Exhibit 4 is Mr. Gom's written testimony that was attached to your NOI.
Yes, we do intend to offer that into evidence, with the exception of the workbook, which is noted in footnote 1, which the hearing officer has previously ruled is not admissible.
All right, and so then there are a few other things in the testimony that we already discussed. The tables based on the workbook, which will be included in the record as part of an offer of proof. So it's kind of a mixed status of admission here. Understanding that those parts of it based on the workbook are part of an offer of proof. Are there any other objections to exhibits 3 or 4? That's the resume and his testimony.
Well, I have no objection to exhibit number 3. He's testified. Exhibit number 4 seems to be a supplementation or a addition to his testimony offered today. And it has a number of problems with it. I don't see how you can distinguish the information that he's offered in exhibit 4 from the work that he relied upon, which is in the workbook, which he describes in this attachment as his exhibit number 1. That's the first problem with it. The second problem with it is that it contains a number of references to, I would call them hearsay discussions with EOG, a discussion with Chair Sandoval that I would suggest is inappropriate. You'll see that on page 6, and then a discussion with Sandoval on page 7. I don't see how that is appropriate given that he is testifying here today. It also contains, this exhibit 4, an entire section devoted to the rule amendments that the commission has determined are not appropriately before them. So I don't see how you can piecemeal this. It would suggest to you that Mr. Gom has provided his testimony. Exhibit 4 should be excluded.
Okay. Mr.
Madam Hearing Officer, OCD concurs with Mr. We concur with Mr. Felderwert's objection and his analysis.
All right, thank you.
As does IP&M.
All right, thank you, Mr. Cloutier. Mr. Micklejohn, let me ask, we did hear Mr. Gom, knowing that there are large fractions of exhibit 4 that are objectionable, some of them subject to a ruling prior to this hearing and some of it subject to rulings during the hearing. Is there anything in exhibit 4 that you would have Mr. Gom add to his spoken testimony today so that the entirety of exhibit 4 really stands as an offer of proof, which is in the larger record, but may not be weighed by the commission in their deliberations?
Thank you, Madam Hearing Officer. First of all, we do not object to the exclusion of the portions of Exhibit 4 that go to the proposals that were advanced by the interveners that are not part of this hearing. On the other hand, the reference to hearsay is not an objection that is well taken because the rules of evidence don't apply in this proceeding. And I think that Mr. Gom would testify that the figures and the graphs within his written testimony are based on the data that also was part of the workbook, and that the workbook was merely a conduit for those data, and that if the data themselves support the graphs and exhibits within his written testimony, that those graphs and exhibits are properly before the commission.
I would like to move past this issue. Let me ask Madam Chair. Madam Chair, there are a couple of ways we can handle this. Sometimes objectionable, a larger document that's objectionable can be redacted so that you have in your hands just parts that are not objectionable. That takes time and presumably wouldn't be able to be done today, for example. Another way is to ask the commission to disregard those portions that are objectionable or have been excluded. What is your preference here?
What would the redacted, what does that even like practically look like?
Well, so we would ask Mr. Gom to go to the trouble of, well, Mr. Gom and Mr. Micklejohn to go to the trouble of removing the objectionable parts of Exhibit 4, which, as Mr. Felderwert notes and Mr. Ames with his concurrence, there are a fair number of things that are objectionable in there. Either going to the interveners' proposals that are not before the commission right now, the references to the workbook, let's see, the statements that go to the workbook that would not sort of go generally to the data found on the page. Mr. Felderwert had another objection around statements he made in connection with conversations with you. As Mr. Micklejohn notes, hearsay is not necessarily excluded in an administrative rulemaking. But I'm wondering,
I mean, that sounds like it probably would slow down the process.
That's my fear. That's my fear.
I mean, my inclination would be that the commissioners either need to disregard it or give it sort of the weight during deliberations as necessary, you know, taking into consideration that pieces of this were excluded in the original proposal or in the motions hearing, and not do the redacted version.
And this is Mr. Moander speaking. I think when we've got an order excluding, and I haven't heard what I would construe to be some, and this is slightly more technical than the rules that apply to this hearing allow. But if there's been an exclusion and no other alternative grounds have been sufficiently laid and demonstrated for it, I mean, the order is pretty straightforward. So it's excluded. My suggestion is that it be disregarded because that's the ruling that applies to this hearing. It's the law of the case.
So, Mr. Minder, certainly those sections that are objectionable, as described by Mr. Felderwert, would be excluded. I guess I was.
I may have misunderstood the question then.
Okay, not inclined to exclude all of Exhibit 4 insofar as some parts of it really do just support the petition. That is to say, the petition filed by OCD and Wildlife Guardians, and to the extent it supports the petition and is not objectionable for one of the 3 reasons mentioned by Mr. Felderwert, it seems to me that the commission ought to be able to at least weigh it in their deliberations.
And I agree with that then. I think I got my wires crossed. But yeah, that makes sense, and that is fair.
Okay. So I'm sorry that is not a clear ruling, Mr. Felderwert and Mr. Ames. I've had clearer rulings before, but I don't really want to toss out the baby with the produced water, I guess. So Mr.
That was a good one, Madam Hearing Officer. Very good. I chuckled.
Okay. So Mr. Micklejohn and Mr. Grom, if you would please just understand that when the commission weighs Exhibit 4, they are going to have to be weighing it with an eye to not weighing those parts that are objectionable as set out by Mr. Felderwart, and yet weighing the other parts that support the petition.
Madam Hearing Officer, may I make one more comment, please?
Yes, who is this? I'm sorry.
It's Norm Gom.
Oh, yes, Mr. Grom. I'm sorry.
Madam Hearing Officer, is this testimony again? He needs to be called properly to make a comment. Plus, I believe Mr. Felder was not afforded an opportunity for cross.
Right, I haven't excused Mr. Gom. Mr. Gom, do you have a question about our discussion on Exhibit 4? I'm sure it's excruciating.
I don't have a question. I did offer in my testimony concerns I have about the quality of Oil Conservation Division data that don't relate to the workbook. They relate to my observations about the data themselves, and I think they are pertinent to the Commission's decision.
All right, thank you for that observation. Let's go then. Now I've lost my place. Mr. Micklejohn, I understand that you were finished with your questions of Mr. Gom.
Madam Hearing Officer, I had one other question.
Go ahead.
Mr. Gom, do you support the amendment proposed by the division and Wild Earth Guardians?
Yes, I wholeheartedly support that amendment.
Thank you.
Thank you, Mr. Micklejohn. Mr. Ames, do you have questions of Mr. Gom?
I've already asked my cross, Ms. Orth, thank you. And I don't want to cross Mr. Gom on his additional testimony. Thank you.
Thank you. I'm sorry if I'm duplicating a step here. And I think Mr. Timmons, you said you didn't have questions.
I didn't, but I actually, if sort of given this ruling and not entirely sure what's still in the testimony, I have just one clarifying question, if I may.
Go ahead.
All right, Mr. Gom, excluding your workbook analysis and based on your review solely of the data from OCD's database, do you have an opinion about whether spills reflected in that database are preventable or not?
I testified that I believe that the vast majority of spills are preventable, and I provided my professional opinions both orally today and in written testimony as to the reasons for my professional opinions. I'd be happy to reiterate those if you wish.
I think that's unnecessary. Thank you, Mr. Gom. No further questions.
Thank you, Mr. Timmons. Mr. Cloutier, I believe you said you had no questions.
Yeah, I asked my question, Madam Hearing Officer, after Mr. Ames, and so have no further follow-up.
All right, thank you. And Mr. Felder, we're back to you.
Thank you. Thank you. Mr. Gom, I think you stated that your discussion of releases or your review of the data on releases demonstrates that there's really two categories, preventable and unpreventable, correct?
No, Mr. Felder, I testified that I believe the majority of releases are, in my opinion, preventable, and I don't understand enough about the other causes to draw a conclusion about whether they are preventable or not. Lightning certainly isn't preventable. Vandalism could be prevented by fences or better security. So there's more would have to be known about the circumstances of spills, individual spills, to draw a professional conclusion as to whether or not a particular spill was preventable or not.
Okay, I thank you. So you would need more information than what you saw.
I would need more information than exists in downloaded data from the Oil Conservation Division from the database entitled Spills and Incidents.
Okay. And your discussion that you had here today was based upon your review and what you called analysis of those division records, correct?
Correct.
Okay. And you're aware that the current rules require the division to be notified of releases?
Yes.
And that when the division receives these notices, they do go out and investigate to get further information as needed. You're aware of that, correct?
I'm not aware that the division does go out and investigates individual spills.
Are you saying they don't?
I'm not saying that. I'm saying I don't know. I don't think the division has the wherewithal to inspect well over 1,000 spills a year.
Would you agree that the division will also have the ability, and perhaps does, go out and review the severity of the release and the risk that's associated with that release?
You know, I have numerous questions about the Oil Conservation Division data. I have posed those questions in writing, and I would like to get answers to them. So, no, I don't know what you suggested I might know.
Okay. So whatever the division did, let's put that aside. What we do know is that all you did was look at the data on the division website. You did nothing further with respect to any of those releases.
I spent an enormous amount of time looking at an enormous amount of data, and I drew conclusions from it.
And the data that you looked at was limited to the information on the division's website.
That is correct.
And that information, I believe you have characterized, Mr. Gama, correct me if I'm wrong, that the data you relied upon, you would characterize as being deficient, correct?
That is absolutely correct.
And you characterize that as being of poor quality.
That is also correct. Would you like me to give you some
also
examples?
Stated that the data that you relied upon is incomplete and inadequate.
Mr. Felderwart, the division's data is replete with blanks.
Here's my
Great
question
numbers
to you,
of
Mr.
spills
Gama.
have no final reports.
Mr. Gama, here's my question to you. Didn't you also characterize the data that you relied upon as being incomplete and inadequate?
Mr. Felderwart, as a professional with—
Yes or no, Mr. Gama? Yes or no?
Madam Hearing Officer, I object. Mr. Gum does not have to answer the question yes or no. If he wants to explain his answer, he can do that.
It's
Right.
his terminology.
So, Mr. Mickles, on that, the way Mr. Feltworth posed the question, it was a yes or no answer. And then if Mr. Felderwart wants to hear an explanation, he will ask for it. Otherwise, I will certainly provide you the opportunity for follow-up when he's done with his questions.
So, Mr. Gama, didn't you characterize the information that you relied upon as being incomplete and inadequate?
I did.
Now, you've also raised concerns about the Sierra Club's ability to participate in these proceedings. You raised concerns about the timing of being able to offer amendments that you believe are necessary. Mr. Gama, if I look at your resume, I believe you were an activist in 2018, were you not?
Yes.
And the Sierra Club organization existed in 2018, correct?
Yes.
And are you aware that the commission had extensive hearings on Rule 29 in 2018?
I am. I wasn't contemporaneously.
Can you explain why neither you nor the Sierra Club participated in those extensive proceedings 6 years ago?
I have no knowledge of why the Sierra Club didn't participate. I did not participate because I didn't begin looking at oil and gas waste issues until 2020.
Okay, let's talk about that. If I read your experience, if I'm correct, and correct me if I'm wrong, I believe you characterized as your experience is in water and wastewater facilities management.
I have experience in that field.
So that would be design, construction, management of municipal water systems.
And wastewater.
And by wastewater, you mean what I would, or some people would call sewage systems.
Yes.
Okay. I believe, and to be fair, I think you also testified that you have experience with water resources management.
I do.
And when you say water, Mr. Gom, you're talking about fresh water.
I'm talking about groundwater and surface water in rivers.
Drinkable, potable water.
No.
Utilized,
Water
I'm sorry,
is not
utilized
potable.
in systems.
1 minute at a time, please.
Sorry, you're talking about water that's utilized for drinking and use.
No, sir. I'm talking about water resources that has not been treated to be potable.
Okay. You're not talking about produced water.
No.
And in fact, if I read through your resume, Mr. Gom, you have no experience with oil and gas operations, do you?
I don't.
Or oil and gas facilities?
I don't.
And you don't have any experience with produced water itself?
I didn't understand your question.
You don't have any experience with, for example, the management of produced water?
I do not.
And you don't have any experience with produced water facilities?
I do not.
And you don't have any experience with dealing with produced water releases?
I do not.
Okay. That's all the questions I had. Thank you.
All right, thank you, Mr. Baldor. Commissioner Bloom, do you have questions of Mr. Grom?
Hearing officer, I do. Thank you. Mr. Gom, thank you for your testimony today. Mr. Gom, was the data you looked at sufficient to show, number one, the number of spills, and number two, the operator that reported the spill?
Yes.
And as I heard your testimony, it seemed to me that the deficiencies and inadequacies you mentioned were related to details of the spills, and that, as I see it, as you were saying that you would like to see more information about what happened in the case of each spill. Is that correct?
That is correct, and I would like to see the Oil Conservation Division concentrate on improving the quality of its data.
Can you elaborate on what that would look like, quality of data?
The quality would mean that, for example, there were some 1,200 liquid spills in 2020. I believe the Oil Conservation Division requires that the depth of groundwater be reported for all of these spills. Yet the data that are available for download show the depth of groundwater is being equal to 0 for each of them. And there are other similar things. For example, the oil conservation spills data has fields for the date of notification and the date of a final report. Many very old spills have no date for a final report. If there was no final report required, the data that's available to the public should say not applicable. But what does a blank mean when there's no final report? I don't know.
And Mr. Gom, I believe I heard you say that there were 400 spills in which there was no volume reported.
I believe I said 400 spills that were classified as major with no volumes reported.
These were the inadequacies and deficiencies you saw. The adequacies and deficiencies weren't related to the overall number of spills in the database or the operator that was being associated with each spill.
That's
Is that correct?
That is correct.
Okay, thank you. And just one other question. I did notice, and Mr. Felderwerk pointed this out as well, that you have background and have done work in water resource management. We've spoken, I think, at length here today about or in some detail about public health and environment and how these proposed rules could improve and protect public health and the environment. Water resource management is certainly part of protecting public health and the environment, particularly in a water challenged state such as New Mexico. Is there anything you'd like to add as someone that has worked in the area of water resource management?
Well, I would like to add that once water is contaminated, it's basically lost from use. That's been the case all over the state with pollution of large volumes of groundwater, which then are effectively not a resource for the future of the people of New Mexico.
Thank you, Mr. Gum. I have no further questions. And Madam Hearing Officer, if we might, we're hitting about the 2-hour point. I think we're wrapping up our questions for Mr. Gum, but if we could have a little break here in the next bit, that'd be wonderful. Thank you.
Yes, that was definitely my plan. I'm wondering, in fact, if perhaps we should break right now because I saw Mr. Micklejohn disappear from the screen. I just checked the participant list and I don't see him. Mr. Lamkin, can you see whether Mr. Micklejohn is still with us?
Don't see him right offhand.
So I think let's take a 15-minute break and try to get Mr. Micklejohn back before we proceed with questions. Thank you very much. Mr. Baca, are you good? Okay, I see a thumbs up. We are back after a short break. We are nearly done with the questioning of Mr. Gum, but we had lost Mr. Micklejohn from the call. So Mr. Micklejohn is back. I assured him that he missed really just Commissioner Bloom's last question and answer. So we are moving now to Commissioner Warnell. Commissioner Warnell, do you have questions of Mr. Gum?
Thank you, Madam Examiner. Yes, one question. During our break, I walked down and got the mail, and it's quite warm out in Santa Fe. Mr. Gum, thank you for being with us today. You'd made reference during your testimony here this afternoon of a EOG resource.
Yes, sir.
Yeah. Can you tell me who that resource is?
EOG Resources is the name of the registered operator in New Mexico who produced the most energy from 2017 through 2019.
Right, yes, I understand that. But didn't you say that you had talked to a resource over at EOG?
Yes, I talked to employee that Representative Nathan Small asked me to talk to in the context of legislation that I supported during the last session, but which failed.
Mr. Gum, have you ever been employed by EOG in any form?
No.
No, sir. Okay.
No.
Well, thank you. I have no further questions.
Thank you, Commissioner Warnell. Madam Chair.
Yeah, I just have a couple questions. I think Mr. Micklejohn already got ahead, but I'll just ask it again. Do you support this rulemaking petition?
Yes.
Thank you. I think a number of times you sort of referenced that you had sent spreadsheet to OCD, requested a meeting, and it had been relatively unresponsive, not been able to set up dates, et cetera. Is that correct?
I said that our schedules had not allowed for a meeting.
In one of the responses, did OCD ask you in particular for any proposals you would have to address the inadequacies that you perceived in your letter, yes or no?
I do not recall that.
Okay. In one of the letter or responses back to you, OCD specifically state, we're happy to have conversations about any proposals you or others may have to address the issues on the list in your letter. Have you sent OCD a response back or any proposal to address any of the inadequacies that you perceive in your letter?
Madam Chair, I have not. I was
Thank you.
hoping to have a meeting to discuss the questions that I had.
Has OCD on 2 occasions sent you lists of time, one of which did not work, the second of which OCD received no response on those time proposals? Is that correct?
Yes.
Thank you.
I was on a road trip visiting my grandchildren and was unavailable and was not paying attention to email.
Thank you. On some of the issues, so are you familiar with the rules pre-Part 29, which existed pre kind of 2018?
I am not.
Okay. In some of the perceived data inadequacies, have you reviewed sort of the past rules to see what was required by those rules to align whether or not the perceived inadequacies line up with what the past rule was, and what was reported?
I have not.
Do you believe that OCD should modify historical data? I'll just leave it at that. Do you believe OCD should be modifying historical data?
I do not. And I have observed, not associated with any of the analysis that I did, that historical OCD data changed over 1 week in 2020. That was one of the questions I was hoping to discuss with OCD staff.
I have no further questions. Thank you.
Thank you, Madam Chair. Mr. Micklejohn, did you have any follow-up with Mr. Grom?
I had one follow-up question, Madam Hearing Officer. Mr. Grom, in response to an earlier question, you referenced an individual named Nathan Small. Who is Nathan Small?
He is a member of the House of Representatives, the New Mexico House of Representatives, and he was a sponsor of House Bill 546, the Produced Water Act in 2019.
Thank you. I have no further questions.
All right, thank you. If there's no reason not to excuse Mr. Grom, then thank you very much for your testimony.
Madam Hearing Officer, our next witness is Joseph Hernandez.
Thank you. I think I saw Mr. Hernandez on earlier. There you are. Would you raise your right hand, please? Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do, yes. Yes.
Thank you. And if you would please spell your name for the transcript.
Joseph Hernandez, Joseph, Hernandez, Hernandez.
Mr. Hernandez, would you introduce yourself to the members of the commission?
Yes. Greetings, Yat, Madam Hearing Officer, uh, Chair Sandoval, and members of the commission. My name is Joseph Hernandez, and I am 33 years old from the community of Tolcon, New Mexico, located 7 miles west of Shiprock. I am of the Zia Pueblo people clan, born for Mexican. My maternal grandfather is the Salt people clan, and my paternal grandfather is Mexican. I am the Dene energy organizer for NAVA Education Project, or also referred to as NAVA EP. I have been working in this position with NAVA EP since 2019, focusing on the chapter house communities situated in the Four Corners region. My work has been to effectively engage Navajo communities in renewable energy advocacy.
Thank you, Mr. Hernandez. You referred to a community located 7 miles west of Shiprock. Would you please spell the name of that community for the court reporter to the extent it can be spelled in English?
Yes, it's spelled T-O-K-O-I.
Thank you. You also used the word Dene. Would you spell that, please?
Yes, it's the letter D-I-N-E, and on the E it has, I want to say, it has one of those marks.
An accent?
Yes.
Thank you. Have you prepared a statement to read to the commission today?
Yes, I have.
Would you please read that statement?
Yes. The issues of oil and gas spills in New Mexico is important to me because my family and I hold allotments in Eastern Agency of the Navajo Nation near Nageezi, New Mexico. My community is well aware of the impacts of resource extraction. For example, back in June of 2019, there was an accident with a vehicle and a large industrial tanker truck carrying hazardous oil and gas wastewater on Highway 550. With the heavy industrial traffic on tribal lands, accidents like this are common and can threaten supplies of our communities. During a Navajo Nation Council Nabikiet committee meeting in January 2020, I heard about some of the high-profile spills that occurred on the Navajo Nation in 2018 and 2019. A major 55,000 gallon spill by Enduring Resource of combined crude oil and produce water occurred on February 28th, 2019, within Counselor Chapter borders. It spilled into a tributary to the Escavade Wash that leads into Chaco National Monument. This spill threatened to contaminate the tribe's shallow groundwater supplies. NAVA EP supports Wild Earth Guardians and OCD's joint petition to make release spills of oil-filled waste prohibited. More needs to be done to prevent these spills from happening in the first place. We believe the changes being proposed will strengthen the current rule and will give OCD a much needed enforcement tool to prevent releases that could impact our health, land, and sparse water resource. A prohibition on spills is an important step to help keep our homes and communities safe from unnecessary exposure of toxic release of oil field related spills that contaminate our lands and sacred sites. As our community works to transition away from fossil fuel extraction, this begins the healing process for our Mother Earth.
Thank you, Mr. Hernandez. Let me ask you to spell a couple of the words that you used for the court reporter. The first one is Nagizi.
Yes, Nagizi is spelled N-A-G-E-E-Z-I.
Thank you. You also mentioned a Navajo Nation Council, and I'm not sure I can pronounce the word, committee meeting. Could you spell that word that's between council and committee, please?
Yes, that's we also referred that because we also call that the NABI for short. You know, everybody refers it to the NABI, but yes, capital N A A B I K space I Y A T I.
Thank you. And then the last one is you referred to what I believe is the Escovado Wash that leads into Chaco National Monument. Would you spell the word Escovado for the court reporter, please?
Capital E S C A V A D A.
Thank you. And finally, you said that your organization supports the joint petition filed by Wilder's Guardians and the division. Is that correct?
Yes, that's correct.
I have no further questions. Thank you.
Thank you, Mr. Micklejohn and Mr. Hernandez. Mr. Ames, do you have questions?
Thank you, Ms. Orth. Mr. Hernandez, thank you for your testimony. I have no questions.
Thank you. Mr. Timmons?
Thank you. I would just thank Mr. Hernandez for his testimony as well, and no questions. Thank you.
All right, thank you. Mr. Cloutier?
No questions for Mr. Hernandez, Madam Hearing Officer.
Thank you. Mr. Feldewart?
No questions. Thank you.
All right. Commissioner Bloom?
Mr. Hernandez, thank you for your testimony. I do not have any questions.
Thank you. Commissioner Warnell?
No, thank you, Mr. Hernandez. No questions.
And Madam Chair?
Just one quick question. Are you supportive of the proposal today? Oh, can you guys hear me?
Mr. Hernandez?
Yes, I can hear you.
Okay.
Yes. Yes, I am supportive of the proposal.
Thank you. Thanks for your time today.
Thank you very much, Mr. Hernandez, and we'll excuse you now. Thank you.
Thank you, Madam Hearing Officer. Our last witness is Joseph Zupan.
Mr. Zupan, we can see you on the screen. Would you raise your right hand, please? Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. And would you please spell your name for the transcript?
First name Joseph, Joseph. Last name Zupan, Zupan. 8N.
Thank you, Mr. Zupan. Could you explain for the commission your background and your current position?
I will. Thank you, Madam Hearing Officer, members of the commission. My name is Joseph Zupan. I'm the executive director of Amigos Bravos, which is a nonprofit organization whose mission for over 33 years has been to protect and restore the waters of New Mexico. I've served as the ED of Amigos Bravos now for about 5.5 years. Prior to my role at Amigos Bravos, I worked as an environmental consultant for over 25 years at an Austin-based firm. Some of my clients included oil and gas exploration and production companies. I have a Bachelor of Science degree from the Colorado School of Mines and Chemical and Petroleum Refining Engineering. And I'm currently a licensed professional engineer in New Mexico and Colorado. I've held my license in New Mexico for over 10 years. My technical work in environmental consulting was focused on so-called risk-based corrective action, which entails a calculation of risk posed by spilled contaminants in environmental media. And by environmental media, I mean things like soil, surface water, and groundwater, in order to develop cleanup standards that minimize risk to human health and the environment. And during my tenure in environmental consulting, I was asked by the Texas Commission on Environmental Quality to serve on a committee tasked with developing guidance for the regulated community with respect to the so-called Texas Risk Reduction Program, which is codified at their 30 Texas Administrative Code 350, for the cleanup of contaminated sites using risk-based standards. I served in this role for over 6 years. And all of this is just to say that I'm familiar with oil and gas operations and with the development of a rigorous environmental regulatory program.
Could you explain for the commission, Mr. Zupan, why Amigos Bravos is interested in this particular proceeding?
Yes, I certainly can. As previously stated, the mission of Amigos Bravos and the objective of its several thousand supporters across New Mexico is to protect and restore the waters of New Mexico. The three primary areas of our work are restoring watershed health, holding polluters accountable, and building a water protection movement for the future. Our specific concerns with the oil and gas industry in New Mexico include the impacts that spills have on New Mexico's surface and groundwater resources, as well as on public health and environmental receptors. We do view the number and extent of spills as very problematic, as outlined by Mr. Gom and as shown in the OCD database. I would also note that as per Mr. Cloutier's comment, we do support the reuse of produced water within the industry in order to minimize the consumption of New Mexico's scarce freshwater resources. So that's kind of the objectives and the concerns of Amigos Bravos with respect to this rulemaking.
Does Amigos Bravos support the petition that was filed by the Division and Wild Earth Guardians?
We do. We very much appreciate the application by Wild Earth Guardians and the Oil Conservation Division to prohibit the unauthorized release of oil, gas, produced water, and other contaminants, and to clarify the division's authority to enforce this prohibition on major and minor releases. We do see this as a very, very important step in protecting human health and the environment from the impacts of oil field releases, and we commend both petitioners for this application. We also commend responsible industry parties for supporting the rulemaking. We appreciate you. Like the Sierra Club, we've also publicly advocated for budget increases to the agencies responsible for regulating such spills, including both MNERD, of which the OCD is a constituent, and the New Mexico Environment Department, to ensure their staff has the necessary resources to address the magnitude of the problems they're trying to regulate. Given the number and nature of spills since 2018, I guess I should say we also appreciate the tightened rulemaking in 2018 that the division and Mr. Griswold in particular, it sounds like, undertook to tighten up the rules for how to respond to spills. But given the number and nature of spills since 2018, it's clear to us that more work remains to be done. We do see this rulemaking as a good start, but we encourage the OCC to consider what additional steps may be required. And we urge the Oil Conservation Commission to adopt this rule.
Thank you, Mr. Zupan. Did he attach your resume to the notice of intent that we filed as part of this proceeding?
We did.
And is that an accurate resume?
It is.
Thank you. I do not have any further questions for Mr. Zupan.
Thank you. And you offer presumably Exhibit 2, which is his resume.
Yes.
I'll just pause a moment here for objections if there are any. Oh, Exhibit 2 is admitted. Thank you. Mr. Ames, do you have questions of Mr. Zupan?
I do not, Madam Hearing Officer. Thank you.
Thank you. Mr. Timmons?
No questions. Thank you.
Thank you. Mr. Cloutier?
No, Madam Hearing Officer, no questions.
Okay, thank you. Mr. Felderwerth?
Thank you, Madam Hearing Officer. No questions.
Thank you. Commissioner Bloom?
Yes, thank you, Madam Hearing Officer. Mr. Zupan, thank you so much for your testimony today. No questions. Thanks.
All right, thank you. Commissioner Warnell?
Thank you. I have no questions.
Thank you. And Madam Chair?
A real quick one. Do you support the proposal today?
I do. Thank you, Madam Chair.
Thank you. Thanks for your time today.
Thank you so much, Mr. Zupan. And I think we can excuse you now. So thank you very much for your testimony.
Thank you, Madam Hearing Officer. We do not have any other witnesses. We do move the admission of the resume for Norman Gaum that was attached to our notice of intent. And I believe you've already admitted Joseph Zupan's resume. And I recognize that the other exhibits that we offered are somewhat in limbo, I guess I would say at this point. But we urge the commission to admit them.
All right, thank you. So I may have already admitted 3, but if I did not, interveners 3 is admitted, and Exhibit 1 was excluded, and Exhibit 4 is excluded in part and will be considered in part, consistent with our earlier conversation. So you have no other witnesses, Mr. Mickeljohn?
That's correct, and we have nothing further to present unless the commission wants to hear a closing argument.
All right, we'll talk about that in just a second. The petitioners, Mr. Ames or Mr. Timmons, did any of the evidence prompt in you a desire to offer any kind of rebuttal?
Thank you, Madam Hearing Officer. The division has no rebuttal witness. Thank you.
Nor does Wild Earth Guardians have any rebuttal witnesses. Thank you.
I mute myself. We should talk then about closing arguments and deliberations. Mr. Lamkin has just put something in the chat to the effect that he has had no other requests to make public comment through the chat, but let me just offer that as an opportunity now. Is there anyone who would like to offer public comment, non-technical public comment? If you can hear me, please communicate with the technical host through the chat function if you would like to offer public comment. All right, and in the event you would prefer to put your public comment in writing. That comment is due, the deadline is in about 2 hours at 5 p.m. Because the commission will consider everything that comes in before 5, they will not be deliberating before 5. We do have all of tomorrow, starting at 9 for their deliberations. Madam Chair, what is your preference? To have verbal closing arguments and to deliberate tomorrow, to have verbal closing arguments tomorrow and then deliberate tomorrow, or to put off deliberations for another meeting and to have closing arguments in writing? Those are the 3 options I can think of.
Well, I think we can deliberate tomorrow. I guess I'll ask the commissioners, but I feel comfortable deliberating tomorrow morning. We have the written comment deadline of 5 today. If any come in at that point, they will be sent to the commissioners so that everybody has all of the information. But I think we deliberate tomorrow morning. And I would advocate for doing closing arguments now.
Madam Chair, I agree.
Commissioner Warnell, are you on board? I think you're muted.
There it is. I'm sorry, Madam Chair. Yes, I
You're
agree.
fine. Okay. All right. Closing arguments now, if any choose to do that, and deliberations starting at 9 o'clock tomorrow.
All right. And Mr. Binder, I see you on my screen. Did you have something to add at this point?
So just to kind of make sure that this matter's papered properly, I think under 1915-313 of the NMAC, so the deliberations can be moved into, or can occur right after the completion of the rulemaking hearing. The issue is the rulemaking hearing, to a certain extent, from my view, really isn't going to be complete until tomorrow, primarily because we have the 5 p.m. deadline today, which is the close of business. So I think legally the commission's in a good position to do deliberations tomorrow. I don't have a problem with that. And then there was one other section I was going to cite for the record, and I've apparently misplaced that. But yeah, so I think that's where we're at on this. If any parties have objections to that, I would like to hear them now so we can suss this out. But I think that should work.
All right, thank you. I'm just going to pause for a moment, not do a roll call, just pause for a moment. Do any of the council have objections or contrary observations if we are to go to closing argument right now and pick up deliberations at 9 in the morning?
No, Madam
No
Chair.
objection.
All right, thank you. Sorry?
No objection, sorry.
All right, thank you. So that I did hear Mr. Ames, Mr. Meiklejohn, Mr. Cloutier.
Could we get Mr. Felderword on the record with his position as well, please? I just want to be thorough here.
All
You
right.
want my official position, Mr. Bolander?
Yes, I'd like to hear your official position.
No problem with what's been proposed.
Excellent.
And NMOGA does not have any closing statement or closing argument.
In abundance of caution, I just like making sure of this stuff now because, well, I don't know, the attorneys here understand why. So thank you very much. I appreciate it.
I say that without hearing what anybody else wants to do, but I don't see a need for one.
All right, thank you. And Mr. Timmons, I trust you're on board.
No objection. We would like to offer a short closing as well.
All right, thank you. Mr. Ames, why don't you begin the closing arguments?
Thank you, Ms. Orth. OCD respectfully requests that this commission adopt the proposed changes to Part 29, prohibiting major and minor releases and making them subject to enforcement, and to both in the rule and in actuality will incentivize operators to exercise due diligence to avoid releases in the first instance. The proposed changes are authorized by the Oil and Gas Act because they protect public health and the environment from waste. They are supported by all the parties and their witnesses, and there's been no testimony or comments in opposition to them. Now, some commenters have proposed other changes. In our view, they cannot be considered in the absence of a valid petition. Other commenters have also alleged that the agency has failed to bring enforcement actions and suggest that the agency is somehow complicit in harming public health and the environment. We disagree, but then that is not the point of the hearing, and I'll have no more to say about it. The Commission's purpose today is to hear the proposed changes to Part 29 proposed by the Oil Conservation Division and Wild Earth Guardians. Our petition has been properly noticed. We have offered appropriate and adequate testimony and evidence to support it. Accordingly, we respectfully request that this commission adopt the petition as proposed so that the agency can get on with its business of regulating releases to protect public health and the environment. Thank you.
Thank you, Ms. Rames. Mr. Timmons.
Thank you, Madam Hearings Officer, Chair Sandoval, members of the commission, and everyone who has participated here today. I want to thank you for your time and attention to this matter. As I noted in my opening statement, this joint proposal before the commission, filed by Wild Earth Guardians and the Oil Conservation Division, is a straightforward proposal to prohibit major and minor releases. As Mr. Ames indicated, no party appearing here today opposes this rule modification. All of the witnesses who have testified support the rule, and the vast majority of public commenters support prohibiting releases of crude oil and fracking waste. But just to briefly get into the weeds on a couple points. First, the only opposition to this rule that I'm aware of came in a written comment letter from Intrepid Potash, New Mexico, I believe referenced earlier by Commissioner Bloom. Now, that comment letter expressed concern regarding the potential for civil penalties to be assessed on what it characterized as de minimis spills. But that concern is overblown for a couple reasons. One, this rule does not apply to de minimis spills, but only kicks in for what are termed or defined as minor spills in the Commission's existing regulations. And so these are spills of 5 barrels or more. That's more than 200 gallons. So it's certainly not de minimis when we're talking about spills of crude oil or fracking waste, including produced water. And two, as Mr. Ames explained, imposition of civil penalties is not an automatic process, but it's subject to the enforcement discretion of the division, which takes into account a number of considerations, including spill volume, threat to public health and the environment, and the operator's particular response to the spill at issue, as well as compliance history. The second issue I want to address is the testimony of Mr. Gom. In his cross-examination of Norm Gom, Mr. Felderwert questioned Mr. Gom's background and the reliability of the data that Mr. Gom based his testimony on. But no offense to Norm, his testimony is not needed for the commission to approve this rule. As Mr. Griswold indicated, OCD records show about 12,000 reported spills from 2010 to 2020, about 3.5 spills every day. And that testimony is unrebutted. So Mr. Felderwert may dispute my characterization of 3.5 spills every day as too much, but the numbers speak for themselves. And so we would urge the commission to adopt the joint proposal as amended by OCD's minor modification included in its notice of intent. Thank you.
Thank you, Mr. Timmons. Mr. Cloutier.
Thank you, Madam Hearing Officer. I made an opening statement where I made most of my points to the commission. I don't want to repeat those. I appreciate the commissioner's attention and yours. I would only add that there were some afactual comments about the oil and gas industry that were made in public comments. And as Mr. Felderwert did at the beginning of the morning, while we vigorously disagree with those and Mr. Ames disagreed with characterizations about the division, which I would second him on that, those comments and are not pertinent to this rulemaking. And so other than noting my disagreement, I'll leave them alone. Thank you for your time.
Thank you very much. I trust, Mr. Feldewart, you haven't changed your mind.
I do have to say one thing, and just to clarify, I know Mr. Ames talked about the proposals, the modifications to the rule that were proposed. Those include, I assume, what you see in the division's exhibit number 6, which is the reference to part 27 and 28, which I think everybody agrees is necessary.
All right, that's my understanding. Let's see here, Mr. Micklejohn.
Thank you, Madam Hearing Officer. Thank you, commissioners. We appreciate very much the time you've devoted to this. As our witnesses indicated, the interveners do support the proposal advanced by Wild Earth Guardians and the division. And I would ask the commission to consider that is support not just from environmental groups, whose support I think is quite important in terms of the impacts of spills on New Mexico, but also from representatives of frontline communities. So you're hearing from people whose communities are affected on the ground when spills occur. That is significant. We urge you to take that into account. We urge the commission to adopt the proposed changes to the regulations. Thank you.
Thank you very much, Mr. Micklejohn. Madam Chair, I believe it is time to close at least this portion of the record. Again, the written public comment opportunity is not closed until 5 p.m. today. And you'll find the email address to which you can send written public comment in the public notice. So unless there's anything further, we will be on a break until 9 o'clock tomorrow morning.
Sounds good to me.
Thank you all very much.
Thank you, Madam Hearing Officer.
Thanks, everyone.
Thank you.